Petition allowed. Allowed.
May it please your lordship. I beg to mention item number 20. Kindly be adjourned for the day.
The appeal being made by Mr.
M.S. Hussain.
M.S. Hussain, learned counsel for the accused, raises the list the matter. When?
After vacation, lord.
After vacation.
Much obliged. May I please your lordship? With the consent of the other side, lordship, I beg to mention item number 21. And
21.
21, lordship. I have
The-
second consent.
On the appeal being made by Mr.
U.B. Sharma.
U.B. Sharma, learned counsel for the appellant. With consent from the other side, raises the list the matter
After vacation.
after vacation.
Yes,
Yes.
Lord. My lord, I think for listing, filed on 16/12, my lord. Here the IO.
When do you want?
My lord, tomorrow or Friday. My lord, the planet for the selected our prayer, I think that.
Okay.
May I please your lordship. My lord, with regard to item number 26, we have filed a connected interlocutory application, my lord. My lord, for impleasement of the present director of higher education as a party respondent, my lord. My lord, pray that the I may be called for.
Okay.
My lord, highly obliged.
May it please the lordship.
Huh?
Lordship, item number 30 has been wrongly listed for orders today. It may be taken up for admission after vacation, lordship.
I in this case, I'm appealing for 1, 2, 3.
Item number
30, lordship.
30. Okay. January.
For admission, lordship.
Okay. As agreed by learned advocates of both the parties, raises the list the matter after vacation in the admission column.
Let me please.
When?
Part of January.
Okay.
Much obliged, lordship.
For admission matter.
Okay.
May I please, your lordship. Lordship, item number 1, my lord. My senior L.R. Mozumdar, who is out of station, my lord. Kindly observe for
On
this.
the appeal being made by Mr.
A. Khalek.
A.
Khalek, on behalf of L.R. Mozumdar.
A colleague learned counsel appearing on behalf of Mr. is a L.R. Mazumdar,
L.R. Mazumdar.
learned counsel for the accused, raises the list the matter. When? When do you want?
After
After
vacation.
vacation. Okay. After vacation.
Obliged.
I please your lordship, item number 22. The counsel for the petitioner or out of town seeking medical help, lordship. So please the matter after the PU break.
On the appeal being made by Mr.
NJ
Your name,
Demari, Lord.
learned counsel,
Yes.
appearing on behalf of Mr.
G. Bordolo.
G. Bordolo, learned counsel for the appellant, raises the list the matter after vacation. PU vacation. Okay.
May I please, lordship? I beg to mention item number 37, lordship. We need to file substitution petition. Matter may be taken after vacation, lordship. We have taken concept from the other side.
You have a appellant or the
Appellant
your name
R. Bharali on behalf of H. Buragohar.
on behalf of
H. Buragohar.
Ace.
Buragohar.
So learned counsel.
37.
37. His name is not there. 37.
Yes. His name is not there. There is another On behalf of Sir Lordship Appellant,
You are appearing Mr. On behalf of Mr.
Second.
Buragohai, but his name is not
Sir-
there in the court list. You see,
case number is MAC 33 of 2022.
the learned counsel appearing on behalf of Mr. Buragohai. Learned counsel for the appellant, principal is the matter. You inform the other side.
We have taken consent from the other side.
Principal is the matter. When do you want?
After vacation, highly
After-
obliged.
May please to Lord. Malad,
Yes,
this review application under Article 237 is preferred against the judgment and order passed by the London additional district Hailakandi, whereby and wherein the assessment, the compensation assessed by the local revenue authority that has been by illegally enhanced, my lord. In a similar petition, my lord, your lordship has already passed an order, my lord, that I have put it before your lordship, my lord. This similar order may kindly be passed, my lord. Thank you. The compensation manner the assessment for drawing the high tension line, my lord.
yes, sir. Madam, you are appearing for status. We will pass similar order. then.
But simple, but there is no interim prayer also, my lord. There is similar order may kindly be passed, my lord.
Okay.
Yeah, and this may be made analogous to this item, my lord. This my lord,
So all are to be take together.
to take together, my lord.
Okay.
One and
1 and 2. Okay.
Hmm.
Okay.
Just I am producing
Yes.
the particulars, my lord. Obliged to lordship.
So you were assisted by madam. Your good name.
Yeah.
Sure.
Three and four same.
Okay.
Three and four same, my lord. Item 5.
Yes, yes, sir. Method, method, along with item along with their being
Item 5.
Made with the Lordship. Lordship, I have filed this CRP against 3 orders, Lordship. May I just summarize what has happened in this case? Initially, the suit was filed for specific performance of contract, Lordship. I am the defendant. Now, Lordship, the case proceeded to the stage of
So you have been debarred from cross-examination of the witnesses.
yes, and I have also been debarred from leading my evidence also. That cannot be done. Nothing.
Whether your WS was accepted.
Yes, yes. My W is also accepted. Everything was fine from 2019 to 20.
Which is the relevant part of the order.
No, Lordship, before that, can I just come to page number 46?
What is 46?
What has happened? My engaged counsel has, because I was unavailable because of my treatment of my son, my engaged counsel has withdrawn the Vakaratnama. That Lordship would find at page number 46, the order dated 2/6/2023. Both sides are represented. Engaged counsel for the defendant by petition number
No,
so and
no,
so.
in this revision petition, you are challenging 2 orders.
3 orders, Lordship. The primary order is page number 47. Whereby, since that's why I'm coming to page number 46, Lordship will understand. May I just brief summary of what has happened? Page number 46, Lordship. My advocate has withdrawn his Vakaratnama. So court notices were sent to me. Now court notices were not delivered. And then This impugn order, Lordship would find at page number 46. Notice to the defendant returned without service. As such, I do not feel it necessary to issue fresh notice owing to the fact that the defendant is also duty bound to appear in the trial. As such, cross-examination of DWs are dispensed with. Now, that is also to some extent fine. Then, Lordship, case shall proceed in absence of defendant, fixing 10-10-23 for arguments. From cross-examination of PWs directly to argument. Especially when the case is not running ex parte against me. How can the court do that, Lord? Then, Lordship, I have filed an application for allowing me to cross-examination. The order, Lordship, would find at page number 57. Why that order? On the basis of the fact that I have been long absent, that is for a period of 1 year, they have closed my cross-examination. Lordship, in my humble submission, this cannot be done by the court, Lordship. Then Lordship subsequently filed, I have filed a review application that was dismissed, Lordship, by the impugn order dated 17/8/2024. Lordship would find at page number 69. On the same ground, they have dismissed my application that I remained absent.
Yeah, we'll pass out.
Lordship, what I'm praying, Lordship, the matter is fixed for arguments, Lordship.
When?
Yesterday was
We
the
pass
date.
the order today.
I'm praying for a stay of this proceeding, Lord.
No, we will finally dispose of the matter.
Lord. I'll do it.
Matter number 6. Matter number 6.
Wait, please, your lordship.
Mr. Deuri,
Yes, your lordship.
this is against the order
Yes, your lordship. Page 73.
of refusing to grant exemption.
No, your lordship. This is page 73, your lordship. I am page 75, your lordship. May kindly pay to the last page.
Page number?
Page 75. My only grievance is, your lordship, the circle officer has already given a report, both the circle officers and the court, your lordship, may kindly see page 75. There are 15. May I read, your lordship? Also seen the report of the circle officer wherein the share of the parties has been divided in respect of its dark number. As the report does not appear to be clear as to on what basis the said division was made, as the division is shown to be made in respect of each dark in 9 share, the concerned circle officer directed to appear on the next date fixed. Fixing 25/10/2024 for appearance in circle officer report of Najib. Now, your lordship, there are two reports, two circle officers. Your lordship may kindly peruse. There are two reports by two circle officers, your lordship. It is not clarified as to who is circle officer to appear. One is circle officer Dibrugarh West Revenue Circle. The other one is East Revenue Circle, your lordship. Page 64. Sorry, your lordship. Page 55 is the first report and page 64 is the second report. It's very clear, your lordship. The report is very clear in my respectful submission, your lordship. Vernacular is at page 62, your lordship. May I read, your lordship? Title suit. This was regarding the title suit with respect to partition, Your Lordship. উপৰোক্ত বিষয় আৰু মহামান্য আদালতৰ মুন্সিফ নম্বৰ 1 পৰা অহা টাইটেলৰ দুট নম্বৰ 117/2007 মুঠ চাহেব চৈঞ্চ গোচৰ সন্দৰ্ভত মাটিৰ প্ৰতিবাদ দাখিল কৰা হ'ল। ডিব্ৰুগড় পূব ৱাৰ্ডৰ চক্ৰৰ অন্তৰ্গত চৈঞ্চ নম্বৰ মাটিত শিক্ষা বহি আদি বিৰোধী কোনো নামজাৰি নাই। গাভৰু পথাৰ ৱাৰ্ড নম্বৰ 720। I'm not reading this, Your Lordship. Then Your Lordship may kindly see pata number 51, 1.6 tesa. So this is very clearly mentioned, Your Lordship, how the property is to be divided between the shareholder. Then Your Lordship, page 67, it makes very clear, Your Lordship. The total area, male share, which is 2/19, and female share, 1/19. So this is how the property has been divided, Your Lordship. My only respectful submission, Your Lordship, is that the order is not clear as to which circle officer needs to appear before the Honorable Court, Your Lordship. As there are two circle
Oh,
officers.
why don't you
and
file a petition before the trial court to clarify the matter?
as if, Your Lordship. That was the only grievance. We raised that part, but it was not changed, Your Lordship. Definitely.
Or Mr. Devi, learned counsel for the petition. This petition under Article 227 of the Constitution of India, the petitioner has put to challenge the order dated 7/9/2024, passed by the learned civil judge, Junior Division number 1, Dibrugarh, in title suit number 117 of 2007. Is to be noted here that in the said order, the learned civil judge, Junior Division number 1, has observed that the report submitted by the circle officer was not appears to be clear. Does not appears to be clear as to on what basis the said division was made, as the division is shown to be made in respect of each dog in 9 chairs, and had further directed the concerned circle officer to appear on the next date fixed. Mr. Devi, learned counsel for the petitioner, submits that the impugned order dated 7/9/2024, the learned trial court has not indicated specifically as to which as to which of the circle officer is required to appear in the side court on next date. Yes, there are two circles. One is Dibrugarh East and the other is Dibrugarh
West.
West. West.
Page 63, Your Lordship.
Therefore, Mr. Devi has contended to set aside the impugned order dated page 63. Mr. Devi further referring to the report dated 27/5/2024. Submitted by the circle officer Dibrugarh East Revenue Circle, submits that while impugned order dated so the learned trial court ought to have direct the circle officer Dibrugarh East Circle to appear before the court. At the success, Mr. Terry submits that he will file a petition before the learned trial court to clarify the order dated 7/9/2024 as to which of the circle officer uh, is required to appear before the trial court on 25/10/2024. The date is already over.
Yes, I don't have the date right now, but I was told that nobody appeared on 25/10/2024, Your Lordship. On next date fix, I will place a petition, Your Lordship. Within
When the next date is fixed.
within 2 days, I will file a petition, Your Lordship, if you after taking the certificate.
No, when the next date is fixed.
Right now, I do not have the instructions, Your Lordship. I have to take instructions with respect to next date.
And the further price for granting him liberty to raise the issue before the learned trial court and to withdraw this petition. Accordingly, I find sufficient ground to allow the Dairy to withdraw this petition, granting him liberty to raise the issue before the learned trial court. And in the event of filing such an application before the learned trial court, the learned trial court shall pass necessary order in accordance with the law.
I'm deeply obliged.
Number 7.
My lord, the impugn order is at page 96, my lord, annexure 14.
So the trial court has refused to grant injunction.
My lord, your
So now the question is whether this order is appealable order or revisional order.
my respectful submission, this will not be an applicable order because order 39, it is a preliminary stage refusal, not hearing after the plaintiff and opposite side. So this, I have gone through that, my lord, 227 live. On these three grounds, my lord, we can approach this honorable court where erroneous assumption or excess jurisdiction, refusal to exercise jurisdiction. My lord, why I am saying so, my lord, because if your lordship kindly comes to the fact of the case, your lordship will be very clear. We are running the fishery since 2009. And it started, the defendants, the respondents started disturbing us with effect from 24/8/2023. Annexure 1 is the FIR. Pursuant to that FIR, my lord, a police report was submitted by the concerned police station on 3rd of September 2023. Whereby, my lord, it was
First, you have to clarify whether appeal or revision will lie.
my lord, in my
Because
respect,
I have experienced that in the case of refusal of injunction, always this
appeal lies. My lord, I have gone through it yesterday night also, my lord. In the morning also, I have gone through it. My lord, we have filed several revision petitions before this honorable court, and it was maintained, my lord.
So the orders we will see.
Orders of CRP, my lord.
Yes.
My lord, can it be on Friday, my lord?
Okay.
So that
On the pair being made by Mr. Your good name, please.
H. Das.
Is thus learned counsel for the petitioner that shall leave the matter of the
Number 8.
Please, Lord. If the revision is filed against the order dated 3/7/2024, but see in this case what happened? I am the defendant, number one. The evidence was closed. My argument was over. Thereafter, at that time, the plaintiff filed 3 applications, only for some documents from different authorities. That was allowed, Lord. Page 98 is a long order. Both these applications, I file my objection, stating that at the bank of the end, the petition cannot be allowed because it will be nothing but will be a tactics to delay the trial. The suit is by my sisters claiming that the land which was purchased by me, they are also sharing the property. But if the plaintiff has to stand on their own legs, they have not called for any official witness from the circle officer to examine the said data. Now, when the argument is over, they file application law. The MP notice start is page 91. 98. 98, Lord.
Connection number 9.
The learned trial court says that there is no restriction in calling of the document. But regarding my objection, nothing has been stated.
Is there any object or no? Is there any bar?
No, Lordship, Lordship, at the fag end of the trial. And Lordship, another thing here, Lordship, the suit is regarding partition of the property which was purchased by me. It is a duty of the plaintiff to disclose all the documents at the time of filing WS, Lord. And Lordship, interestingly, they are calling for one discharge certificate from hospital where my father was admitted. That fact was known to them at the relevant time, Lord. And regarding sale deed, they have challenged this sale deed also. Now they said that original will be produced from my position. Then they have not cited circle office as a witness, and no official witness was closed. And interestingly, also when the argument was over, this 3 application has been filed.
No.
Hello.
Is there any restriction in filing the application
No,
before
Lordship,
the
No,
argument?
my submission before Lordship at the fag end of trial and argument was over. And Lordship, interestingly, Lordship, see the suit. What is the suit? Suit is for declaration of right title interest there and partition of the suit. And the land which was purchased by me. And Lordship, I am relying on one judgment of sacrifice, although it is not binding on Lordship. The organization made in paragraph 7 is very interesting. Lord.
Well, let notice go at this.
Lordship.
And third Mr. S.C. Kyle, learned counsel for the petitioner. Order dated 3/7/2024 passed by the learned civil judge. Senior Division number 1, Kamrup M, in connection with title suit number 356 of 2017. Challenge that is petition under Article 27 of the Constitution of India. It is to be noted here that by impugn order dated so the learned trial court has allowed 3 petitions, being petition number 6299 of 2023, filed under order 16 rule 6, dated section 151 CPC, and petition number 6300 of 2023, filed under order 11 rule 14, dated section 151 of the CPC. Then petition number 6301 of 2023, filed under order 16 rule 6, dated section 151 of the CPC. Filed by the respondent, the plaintiff, at the related stage of trial. Where is the petition and the documents class of record? And also where is the impugn order dated 3/7/2024? Let notice be issued to the respondent. Returnable in 4 weeks. It's to be taken by registered also with AD and also by the process. Please the matter on after vacation. Listen the list the matter immediately after reopening the after 4 weeks.
It will be possible that date kindly may be fixed, and on that date, Lordship, my interim period may be considered.
Okay.
Lordship,
Interim period of the petitioner will be considered on next step.
much of it.
Number 40.
May it please your lordship. Preliminary, I perhaps have to address why a revision and not an appeal. I was hearing, my lord, that query would come. If my lord permit me to address that point first. Appeal, being a creature of a statute, the jurisdiction to exercise the appellate jurisdiction is always there when the corresponding statute provide. May I invite my lord attention to CPC, my lord?
Because an injunction order, refusal or grant to it would be appealable order under Order 43. Depending on the territorial jurisdiction, on the pecuniary jurisdiction, the jurisdiction of the higher courts would change. But Order 43 for a moment. And the corresponding provision of injunction would be 43(1)(r), if I may read that, Is the lordship there?
Yes.
My lord. An order under Rule 1, Rule 2, Rule 2A, Rule 4, or Rule 10 of Order 39, meaning thereby the appellate jurisdiction so vested on a court deciding an order granting or refusal of injunction is limited to 39(1), 2, 2A, 4, or 10. And we had filed an application under Order 39, Rule 3. The point is, what is the difference in these two seemingly similar, yet striking the different provisions? My lord, order to grant injunction finally would be under Order 39, Rule 1. If I'm there on that, my lord. Order to grant injunction by trial court, my lord, competent jurisdiction, would be under 39, Rule 1. So that comes at the last. It doesn't come at the first. Now, during the pendency of the proceedings of Order 39(1), if some injunction is to be given, that is, ad interim injunction can be granted under the same provision.
So, Bonnie,
My
there are
lord.
several decisions of the Supreme Court
My lord,
that appeal will lie.
the appeal would lie. What I'm on is that, my lord. Today we are before your lordships under an understanding of this, that since under Order 39(3), which is not included under Order 43, and 3A says 30 days you have to dispose of. In 3A, it's 30 days, this has to be disposed of. I am not seeking an injunction before my lord. What I'm seeking is an ex parte ad interim injunction till day after tomorrow if need be. We go back to trial court. Nothing. I don't seek an injunction. I want to contest with them. I want to mediate with them under Section 89. My case is totally different. I'm not on contest. What I want is that using muscle power, do not barge in when I'm seeking recourse to a court of law. When I've written to you under notice that come, let's talk across table, do not show muscle power. Under these technical difficulties, the Honorable Lower Court, my lord, exercises jurisdiction and was pleased not to give ad interim injunction, but ex parte ad interim injunction. But the error in jurisdiction crept in because the date was fixed on 28th of February. 2 months later, 7th of December, the order is passed, not granting ex parte ad interim injunction when my case is barging in making constructions. 2 months later, date is fixed, and the reasoning is based on a deed of agreement where my entire case was when the power of attorney is executed and the attorney holder dies. He is not a criminal man. He died. That's all. Then we offered to execute a fresh power of attorney with the other persons. No one is coming in. Without any right authority, they are barging in to make things, and third party sale would be there. We said, let us sort it out in papers. That's all we want. We are not even against them. And so we wanted to go ahead under Section 89 mediation. Non-granting of this ex parte ad interim would cost me huge. Now third party rights will be created. The lordship knows I can do nothing. I have to keep buying suits after suits to get those things done. It is in pressings. We are praying for revisional jurisdiction. Appeal, I would have appreciated, my lord, had I been challenging an order of allowing or refusing injunction of the entire case. That stage we have not even reached. We only are on the realm whether they are to be heard before granting a protection for 3 days.
What is your prayer in this petition now?
My prayer is only 39(3), not 1 and 2. Not 1 and 2. Consciously I have taken a call, my lord. 39(3). I do not want injunction. That would be inter parte. I am on ex parte, refusal to grant ex parte. How can I pray inter parte, my lord? I put the question to myself. Therefore, when I pray inter parte, that's on the other case, my lord. That will be at page 18. Only ex parte ad interim injunction. I'm not praying for injunction, my lord. I want them to be heard because then I'll pray for 89. I want to go for mediation. They're barging in, my lord, only till they are heard. 3 days, 4 days, 5 days, 7 days, whenever the lower court is open, I need a disposal of this application. I don't need injunction, my lord. Because if the order would have been passed on the 39(1) and 2, deciding on the merits of the matter, certainly appeal would have lied. It is not an appealable order, my lord. Because no one has touched the merits of the matter. I do not need to touch the merits of the matter at all. But he protects me for 3 days, 4 days, my lord. That's all.
So we have to ascertain whether this revision will lie.
My lordships, in the meantime, we are closing. Friday, we are closing, my lord. If this confusion comes in now, and I have not prayed for any protection order also.
Maybe. But if we pass any order under in exercising this revisional jurisdiction, if tomorrow it will be found that there is no revision will lie, then
That my friend says there's an order in which 227 was appreciated by this court, regardless of the outcome of that. But there'll be one difference from this petition and mine because I've prayed for specifically ex parte ad interim in the honorable court. These are being entertained because under the statute is not appealable, my lord.
some judgments of Supreme Courts are there.
The appellate court judgments also decide on the factum that 39(3)(a) being introduced, that is not an appealable order because 30 days time period is given. So further is not there. Then lordship also has the power to treat as an appeal and pass an appropriate order. My lord, I would be convinced the court is closing, my lord. We are on a different, my lordship kindly understands my agony, my lord. Had we been in normal course of time, so 2 weeks are there to go for the vacation, I still have some time to come before your lordship. Even if I come up with whatever lordship has fallen from your lordship, I appreciate that, my lord. How do I wriggle out of that? Regardless of the fact whether it has been disputed by anyone, whether appeal lies or revision lies, I only want to go back to the trial court and have an inter partes order. Lordship, the date may come forward. The date, no, I would not like to enjoy any relief at their cost. No. The first opening day, let
Okay,
the
come prepared tomorrow with the decision of the Supreme Court.
But I take it to the extreme. In the event,
Pardon?
I take it to the extreme. In the event, what has fallen from your lordship, what I think the appeal would lie. Then would there be a jurisdiction? I put that to myself for conversion and then grant an order. Because that is the test. 115 if I say no. Appeal conversion lies. How your lordship would appreciate the matter.
No.
Because in exigency we are filing
no,
the
no,
case.
no. First, we have to ascertain.
I take it for your lordship.
Under which jurisdiction will
I take it for your lordship because time is less. Supposedly appeal lies. We go by that view.
come prepared tomorrow.
Lordship, may I take it try at 2 o'clock? I'll try 2 o'clock, if not tomorrow. I'll take it try at 2 o'clock.
No, I have some decision of the Supreme
No,
Court.
I'll come with
But
those
are
also.
not available with me right now.
If not, I take it the other way around. If it is appeal,
You come tomorrow.
if it is appeal, would my lordship be able to protect me at 227 application? Because my client is in Bengaluru.
Tomorrow come. You come tomorrow.
Obliged, lordship.
In that case, my lord, my meter also be fixed tomorrow. My item number 7.
Well, I'll pray for. Well, I pray at 2 o'clock.
Today.
Today. At 2
No,
o'clock.
no, sorry.
Only on tomorrow.
When your matter was fixed.
My lord,
Friday,
my Friday.
Okay.
item 7. Kali, tomorrow. Matters for admission, item number 9.
Instructions were called for, Your Lordship.
Yeah, as per my instruction, Lordship, that it will have to be amalgamated with the high school. So it comes under the jurisdiction of the secondary department. Perhaps my Lordship has to make the director in secondary education a party.
Yeah.
Director secondary education is not a party. So it comes under the jurisdiction of secondary education department.
Okay. Third, madam, your good name.
B.A. Ahmed.
Pardon?
B. A. Ahmed,
You are appearing on behalf of
petitioners.
Have communicated the inspector of the school. In the repetition, the factor secretary.
your name is not there in the cause list.
S. Hawk, my senior.
Pardon?
S. Hawk, my senior.
Appearing on behalf of learned counsel, appearing on behalf of Mr. M. Hawk, learned counsel for the S. Hawk, learned counsel for the petition. And also heard Mr. Sharma, learned counsel for the
Elementary education. Elementary education.
elementary education. Mr. Sharma, learned counsel for the respondent authority submits that as per his instruction, the school of the petitioner was amalgamated with
Lot. Pantan ME School.
pardon,
Amalgamated with Pantan High School.
Pantan High School.
PN, Pantan High School.
Height order dated,
Not it
any
was,
order?
it was amalgamated earlier only, because admittedly the petitioner stated that they have been working in the high school. But despite that, the director of secondary education.
Amalgamated with Paltan High School, and as such, there is a requirement for implementing the director of secondary education as a respondent herein. Accordingly, it is provided that the learned counsel for the petitioner shall take necessary step for implementing the director of secondary education as a respondent number. Respondent number 7. Respondent number 7. And also take necessary step to will issue notice only after
Lot.
release the matter. Yes.
Lot no issue.
After vacation, you have to take step within
Step within 2 days. Step within 2 days. Notice 4 weeks.
list after 2 weeks. After 2 weeks.
And lots of SC, secondary education may be reflected in the cause list.
Pardon?
Name of standing council, secondary education may
And
be reflected in the
rest
cause.
shall reflect the name of standing council of the secondary education.
Lot.
10.
Obliged.
May please, Your Lordship. Let us raise to Your Lordship share of family pension. In this case, there is a mother of the petitioner is the mother of the deceased employee. She is a old aged lady, 77 years. She is claiming the share of pension of our deceased son. And respondent number 7, being the wife, she has been receiving the pension. And respondent number 7 is a government employee. She is assistant teacher of the school, but she has not paid a single coin to the petitioner. Despite of service notice, respondent number 7 has not appeared, and Dosti service also taken, but not she has not responding the court's order. On 16/9/24, when the matter was listed before court number 2, the court supposed to pass the direction to her personal appearance, but learned counsel Mr. Christie was there. She has there.
So, you first tell me, by order dated 16/9/2024,
Lordship.
you have been granted
I have filed
which
IA,
time?
Lordship. That I have filed and it is allowed. IA 3433. That is allowed. Your
Allowed.
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 3433. I have now official address. I have made her party. Your Lordship. Earlier,
Achha.
respondent 7 was made as a residential address. Now his official address. Recently, she is an assistant teacher of 520 Nam Palhadi LP School. At this stage, my humble prayer is her appearance is required, therefore she is maybe directed to personal appearance to court. Why she is not responding to court's order, being a government servant, respondent number 7. And further, her pension may be stopped here because she is not, because she is a serving woman, a government employee. And petition before Lordship is a old aged lady fully dependent of her deceased son. I have annexed the next in certificate also, page 20. Page 20, Your Lordship got it. Zainab Ahmed, the respondent number 7, 2 daughters, and sorry for Nessa, at this time 70 years, more than 75 years nowadays. And Your Lordship, provision is there, Your Lordship, and it's page 44. Page 44 of my petition.
Have you filed your amended post title?
Yes, Your Lordship.
When?
I have filed, Your Lordship. I have corrected, Your Lordship, 4A, Your Lordship, page number. Earlier it was Zainab Ahmed, village Palhaji, wife of late Kazim, presently an assistant teacher, 520 on Palhaji LP School.
So when this affidavit was filed
It was forgotten.
with the justice service?
Justice service is a long back there, but affidavit also filed I have. Justice service affidavit also there. And acknowledgement issue of that. So you have the justice service filed on 17/7/23. Acknowledgement receipt also there. He has received. He has received that. Affidavit also there. It is higher to that money.
Who is appearing for the respondent?
On behalf of elementary education, Mr. Swasti is there, and my learning is for higher education. Because
the private respondent is avoiding yes, to this court. He has even filed a dirty.
No, in this petition, we cannot compel her to contest the petition. It's her prerogative. She may contest the petition or may not contest the petition.
it is correct, but your lordship is correct, but other court's view is different. Court number 2 take view that she is not appearing, that she may be person appear. But on that day, my learned
She is a government servant.
Yes,
government
under
servant,
this
that's the
section.
problem. Elementary education.
Elementary.
The assistant teacher of Palhaji LP School. Your lordship.
And that's why the elementary education was made a part.
As per court's order, initially we have made party higher education because the husband of the respondent 7 was a assistant professor of a college. And he died in 26/10/2018. And now the respondent is receiving the pension as well as service also there. He is not paying a single coin. And in spite of notice, justice service is not responding. That's what court number 2 asks that she may be directly person. Why she is not responding to court's order? And asks me that, therefore asks me to amend that his address. Other is a stop his pension, that then she will come. Earlier also he did not pay some gratuity annulment and petitioner approached this court and court part order in page your lordship 31. Page 31 court's order is there, Annex 7, and gratuity and some amount she was received. And she was operative portion page 34. And after that, she received huge amount, more than 40 lakhs. Not a single pen paid.
Oh, what is the relief being sought for against the respondent number 7?
No, Your Lordship. As per the 7 is that he has been receiving the pension. Your Lordship.
Pardon?
He has been receiving the pension and other minimum. I am for the not to respond. Now she is receiving the pensionary benefit and other benefits of the decision of the petition. I am claiming that Your Lordship, prayer, Your Lordship, respondent of the disbursed share of monthly pension, share, Your Lordship. I am claiming share of monthly pension for the period from December till date, other service benefit or late employee cash benefit. And that all the benefits he is
Who is
receiving.
the drawing and disbursing officer?
The higher
Disbursing
authority.
officer of
Your
pension.
Lordship. It is now accountant general, AG.
AG.
AG. Your Lordship. And
Whether AG is the party?
party is Your Lordship. They are appearing Your Lordship every time. But not today. Earlier.
AG or AG only issues the authority.
Your Lordship, higher education. Your Lordship.
Higher education.
Higher education. Secretary higher education. Because this is employee, son was a associate professor at the college. The higher
Have you
education.
filed your affidavit here? You don't want to file it? When?
Immediately after vacation. Because otherwise, pension has been already been paid to the wife
Pardon?
of the petitioner.
Pardon?
The pension has been paid to the wife of the petitioner. Not to the petitioner, the wife of the respondent number 7. We will file that affidavit that we are paying her fee. Then other benefits. Whatever she has got, we will bring that on that.
The claim is Your Lordship, the pensionary matter, old age lazy, she is fully dependent on her deceased son. Now is more than 74 years. She is bedridden at the instructor presently. She is
The respondent number 7 is the daughter-in-law
daughter-in-law
of the petitioner.
of the petitioner. Earlier they were with the petitioner, with the deceased husband. After the death of her husband, she left to her rental house nearby same village and not paying the single coin. Sometimes they return back, sometimes not. And 2 daughters was there. One daughter is already married in the next certificate, and one daughter is with the husband number 7. And petitioner somehow, with the help of relatives, she is surviving. Very critical condition. And moreover, husband number 7 is she herself a government servant. She also not responding. And case is filed to 23 Your Lordship. 10/5/23.
So your prayer is to release the pension and other service benefits.
Yeah, Your Lordship. Yeah. Share of monthly pension and other services.
Let the higher education department file an affidavit.
60 date, first week of January without failure. Without failure because long pending. Last 1 year.
What is the S is the blood and product? Since when it is pending?
2023.
23.
23. First order is 10/5/23. 2 years almost.
And also heard Mr. D. Upamanya, learned counsel for the respondent number 6.
1 and 4.
1 and 4. Higher Education Department 4, 1 and 4. And Madam, respondent number 5. No rule. So this is a not of school, but of college.
College.
Accountant. Then.
Everything is there. Your respondent number 2. Your
And Madam Foreman for respondent number 5. And for rest of the respondent,
For 2, 5, 6, 7, appearing. 2, 3, 6, and 7.
none appears for the 2, 6, and
2, 3, 6, and 7.
2, 3, 6, and 7.
8 and 9 earlier. 11 years, Mr.
Then
Sisti
8
was
and 9.
earlier. Sisti was
And
yeah.
the Upamanya learned counsel for the respondent number 1 and 4 submits that he will file affidavit in opposition and price for granting in time. 2 weeks time. There is accordingly allowed. Price is the matter on of it. Fix it. Next, formal learned counsel appearing on behalf of respondent number 5 submits that by producing a letter dated 22nd of May 2023 issued by the Director of Pension Assam that the respondent number 5 is not a necessary party in this proceeding. As the Directorate of Pension Assam empowers to authorize to issue pensionary benefit to the teaching staff of the Provincialization School, P and RD department and junior colleges only. And since the matter relates to the Director of Secondary Education Department of Secondary Education Department Assam, the Directorate of Pension has nothing to do with the same. And as such, formal phrase that the name of respondent number 5 may be deleted from the array of this petition. We allow her, Priya?
Lord.
Taking out of the letter dated 22nd May 2023 and also the submission of formal learned counsel. Then also taking note of the submission of Mr. Islam learned counsel for the petitioner. It is provided that the name of respondent number 5 may be deleted from the array of the necessary correction may be made in the site according to the network. This is the matter on 20 January. The letter produced by Ms. Foreman shall be part of the record.
Madam, 11 and 12.
My lord, this is for promotion from grade 4 to grade 3, my lord. Instruction agent. My lord. Earlier it was picked for instruction, my lord.
There are 5 posts of the declaration of a secretary without 5 people. Okay.
Hmm. Where?
On the basis of the
On the basis
instruction,
of the-
document dispose of the,
We have already filed their affidavit, my lord, in the
no, the instruction I said.
Pardon?
in my case, they have already filed, my lord.
In our case also, they have filed, madam, government file.
Where they have admitted that we are entitled for promotion, they have admitted.
This case is not related with,
New instructions about it. We can file our additional.
or madam, dispose of, or in terms of this instruction, madam. আমারও তো এই এগুলো কানেকশন নাই না item number 11 মানে petitioner past MA and my lord you have degree of computer.
Let them file a affidavit. We'll fix it that in the first week of January.
My lord.
Third, Mr. P. Talukdar, learned counsel for the petition. And also heard Ms. Karen P. learned standing counsel for the respondent number,
Director secondary education, madam.
secondary education. Director of secondary education. Ms. Karen P. submits that she has received written instruction and she will file an affidavit and press for granting her some time period allowed. This is the matter on of it.
No, 10 9 9
9.
10 will go, my lord.
Okay.
My name will be recorded.
Without pay. Are you party in this petition?
I mean, I think we are.
In 12 also you were petitioner.
I'm the petitioner.
You were the petitioner. Heard Mr. Learned counsel for the petition. Then Madam President. Please the
Okay,
on 9th of January.
my lord.
Items 13 and 14.
Both the cases arises from the same issue, lordship. Initially, both the petitioner filed joint petition, and this is the separate petition, lordship. And in the item number 14, lordship, they have filed an affidavit, and reply has also been filed. And I think, lordship, if my friend is agree, lordship, both the cases cover that affidavit in opposition file in item number 14. And matter is relating to pay scale, lordship. Petitioners are lordship assistant teacher in a high school. Initially, there was a senior madrasa. They were appointed in a senior madrasa, and intermediate pay scale was given. Subsequently, lordship, that was they were appointed in the year 1995. Government of Assam, lordship, issued a notification giving, lordship, the graduate scale of pay to the teachers who were serving in the secondary school. That was issued in 1993. Accordingly, lordship, the petitioners were given that benefit. From, lordship, their initial date of entry, accordingly, they received the graduate scale of pay. Subsequently, lordship, in the year 2008, one teacher, lordship, from another senior madrasa, he filed a writ petition seeking, lordship, the similar benefit given to other teachers of the lordship madrasa. This honorable court, lordship, disposed the said writ petition, saying that the notification of 1993 is not applicable to the senior madrasas, because senior madrasas were provincialized in the year 1995, and official notification that was issued in the year 1993, and the teachers were, lordship, only for secondary school. although the madrasas were under the secondary school. In view of that, Lordship, the graduate skill given to the petitioner that has been withdrawn in the year 2017. Again, that we file a writ petition. This honorable court remanded the matter to the government for examination and pass the necessary order, saying that since the teachers are Lordship, the secondary teachers, and they are imparting the same responsibility and duties. So, in that aspect, Lordship, they were asked to examine the matter and to pass the necessary order. They rejected the claim. Again, that we file a Lordship.
Yes, the present.
My lord, and in between, Lordship, one contempt case was there. In that contempt petition, another direction was also given. That Lordship, after that, again, Lordship, they have rejected this prayer, saying that now the schools are converted to high school, and teachers, they are Lordship FM qualification, so they are not entitled for graduate skill of pay. In fact, Lordship, both the petitioners are FM as well as graduate. They were appointed in initial appointment itself, proved that they were Lordship the graduate Lordship. If your Lordship kindly take the second case, that is item number 14, that is case 28. Is my appointment order Lordship. In fact, Lordship, both the teachers are in the bars of retirement.
When when they will be retiring?
My lord, they will retire in the next year, Lordship. I have stated somewhere, Lordship. My lord, case 28 is the initial appointment order of the petitioner. Here, Lordship, considering upon proposal along with panel of candidates submitted by Superintendent of Secretary so and so, after taking necessary advertisement, the undersigned is hereby satisfied to appoint Abdul Hannan Lashkar, MM, BA. So this is the initial order. At that time, Madrasa Lordship was a Lordship under deficit. Government has provided the salary, and subsequently Lordship 1995 Act Lordship Madrasa Provincialization Act was introduced, and in view of that Lordship, the madrasas were provincialized, page 29. Our in my school name Lordship, serial number 22.
23.
29 Lordship, my madrasa's name Lordship, serial 22.
CL?
22. Bhatir Kupa Senior Madrasa. The notification, that 1993 notification, that I have annexed Lordship, page 32.
That page number?
32. 32. In the interest of public service, all the existing post of assistant teacher in intermediate scale of pay of rupees so and so with graduate incumbent of provincialized high school and higher secondary schools are upgraded to the post of assistant teacher in graduate scale of pay of so and so so and so. These were pertaining to, admittedly Lordship, pertaining to high school and higher secondary school. Madrasas were not included because at that time Lordship, there was no provincialized madrasa in the state of. And subsequently, that is, your Lordship will find page 34. This is the order by which Lordship our graduate scale of pay was granted. In view of that, when a notification, that is 30 December, in pursuance of government notification, that is 30 December 1993. That is that Lordship, page 32 is the notification. Secretary to the Government of Assam Education Department, letter number so and so, dated so and so. The pay of the following graduate teachers of senior madrasa under HDC Hailakandi are hereby refixed on 1/1/1996 as per rules of sub so and so ROP so and so in the upgraded scale of pay. This is with effect from 1/1/1996, showing the date of next increment against this. Name of the petitioner Lordship, serial number 2. This benefit was given on the in view of that Lordship, the madrasa teacher, they were under Lordship the secondary under secondary department, And in view of that, Lordship, this benefit was given. Accordingly, Lordship, we received. And Lordship,
So where is the impugn order?
impugn order, Lordship, that is, your Lordship will find page 70. 70.
70.
Right. May I read? Well, this order was passed in compliance of the order dated 26/8/2021 passed by the Honorable High Court in contempt case number so and so, so and so. In I was Lordship petitioner in that case, Lordship. In compliance of the Honorable Court order dated so and so passed in WBC number so and so, the government in the secondary department had issued an order number so and so dated so and so rejecting the claim of the petitioner for granting graduate scale of pay. But in the meantime, the petitioner filed a contempt case number so and so, and the Honorable High Court disposed of the same on 26/8/2021, directing the then Special Commissioner Secretary, Commissioner of Secondary Education Department to take a further decision on the entitlement of the petitioner for graduate scale of pay. Accordingly, the matter was again examined thoroughly, and it appears that petitioners are FM and MM qualified teachers. My lord, the BA has not been mentioned, Lordship. The teachers of erstwhile madrasas, and the said qualification of the petitioner does not fit into the present syllabus of the Board of Secondary Education Assam for the general school. As and when the madrasas were functional, the theological part of FM and MM qualification was of graduate level standard, and hence any teacher of Dad and madrasas having FM and MM qualification would have taken classes at the senior madrasa. But in the event of abolition of madrasa, Assam Madrasa Education Provincialization Service Rule 2016, the service of the petitioner now governed by Assam Secondary Education Provincialization Service Rule 2018. According to the said rule, the FM and FM qualification does not match with the qualification prescribed for a teacher of high school. As per Rule 14 of the Assam Secondary Education Provincial Service Rule, so and so, a teacher of high school should be graduate in a particular stream or subject with BT BA degree from recognized university. After careful consideration of the above and in continuation to our views expressed in the earlier speaking order dated so and so, it has been decided that the claim of the petitioner for upgradation of their graduate scale of pay, which was withdrawn earlier, cannot be further considered. Well, here, Lordship, our graduation, general graduation, that is BA, that has not been taken into consideration.
So when you have acquired the BA degree,
My lord, I have annexed that certificate also, Lordship.
that page number?
My lord. Case, Lordship, 26 is the FM pass certificate, and 27 is the Lordship BA pass certificate, that is 1996. Page 27, Lordship. This
20?
document, Lordship, they have not considered.
Page 20?
7. FM is equivalent to, Lordship, graduate. Apart from that, the petitioner has the general graduate. And I passed, Lordship, the result was declared on 19 August 1996. Your Lordship will find signature of the control of examination, page 27. And after that, my initial appointment, that is page 28, Lordship, 9 September 1996.
So whether this is what mark sheet?
Mark sheet.
Where is the certificate?
Well, a certificate I have not annexed because I can annex, Lordship, but the mark sheet is, I think, Lordship,
Pardon?
mark sheet is sufficient, Lordship, because unless and until he passed the mark sheet, this is a pass mark sheet. If your Lordship require, Lordship, I'll put this, no problem.
Yes, madam. What is your stand? Pardon? Yes. Yes.
And the passport certificate
pass certificate is required. So whether that certificate was part of the earlier writ
No,
petition?
no, Lordship.
Why you have not enclosed that certificate with the earlier petition?
Every case, normally, Lordship, we are annexing the mark sheet. Mark sheet is Lordship. Enough, Lordship, I think, Lordship, because this is the past certificate, mark sheet, Lordship. After that, normally, Lordship, the certificate issue.
No.
And in my appointment order, Lordship, initial appointment order, my resignation, Lordship, MMBA is given. There is no dispute on that.
In your appointment letter?
Yes, Lordship, in page 28.
Page number?
28. The undersigned is hereby satisfied to appoint Abdul Hamnan Loskor, MMBA. They have considered our graduation at the time of appointment. There is no dispute on that. But
Then what is the stand you have taken in your affidavit?
Era 5. The petitioner was not allowed to go registry of pay or the petitioner are present graduate scale of pay as per the rules under provisions of Government Secondary Department, Your Lordship. It is to be stated here that the post held by the petitioner shall be upgraded to the graduate post only after the retirement of incumbent, Your Lordship.
So your post has not been upgraded.
No, Your Lordship.
My lord, that was upgraded. I received a graduate skill. Up to 2000, Lordship, I have shown you, Lordship. That is.
The upgradation order is available here.
Yes, Lordship.
That page number?
Yes, Lordship, I am giving. Page, Lordship, 34.
30?
34. I have already shown this order.
So that is a refixation order and upgradation of your post.
Refix with upgradation, Lordship. That is, scale is given. That is the graduate scale. Upgraded scale of rupees 35808750, Lordship.
And when this order was withdrawn?
Withdrawn, Lordship, your Lordship will find that is page. Page, Lordship, 47. That was in terms of the honorable court order. That was filed by other petitioner, other teacher. And
so as per order of this court, that was withdrawn?
That was withdrawn. My lord, after that, it just Lordship page 42, one paragraph of the judgment of that judgment. In view of that judgment, our graduate scale was withdrawn. That is Lordship page 42, just one paragraph.
40?
42. Actually, start from Lordship, order start from page 37. Page 42, paragraph 10. Since the benefit of pay upgradation to the graduate scale from intermediate scale was intended only for teacher in provincialized higher secondary school, it is declared that the teacher of senior madrasa are not entitled to the benefit of government notification dated 30/12/1990 2013 is written lordship, it will be 1993.
Hmm.
And order dated so and so, which applies only teacher of provincialized high school, and higher secondary school. And before that lordship is paragraph 8 is important because the one option has left to the government lordship. Although they are not covered because the notification was very specific. That was only for high school and higher secondary school. That's why this honorable court, while disposing this repetition, has given one option lordship, page 41, paragraph 8, last part lordship. Just therefore, lordship can, since an undeserved benefit cannot be made the basis for relief for which the petitioner are ineligible, their claim ought not to be granted. Of course, this is important lordship. It is for the government to take appropriate step on the upgradation granted by the IAS Silchar through the order dated 18/12/2004, but the order cannot be made the basis for similar relief claimed by the petitioner. My lord, that part has already been clarified by subsequent order in our writ petition, that is your lordship, and in the contempt lordship, the relevant part. Our writ petition's order lordship, that is page 53. Page 53. There it lordship just paragraph 3 and lordship paragraph 9. 3 is the factual aspect that has been discussed lordship. Page 55. All the petitioners herein are the assistant teacher of Madrasa intermediate scale and claim that they are similarly situated as those teachers, assistant teacher covered by notification dated 30/12/1993. Accordingly, the authorities upgraded the petitioner to the assistant teacher in graduate scale of pay, though various orders are issued from the year 1996 onward. The said upgradation to graduate scale of pay was challenged by certain madrasa teachers seeking similar benefit as per notification dated 30/12/1993 by filing WBC number so and so. That is the case lordship, earlier case. And other connected petitions, which were dismissed by this court by impinned order dated so and so, stating that the case of madrasa teachers are not covered by the said notification dated so and so. The said dismissal of the writ petition had an adverse consequence upon the petitioner who were already upgraded to the graduate scale of pay. The state government took a decision that since the court has held that the madrasa teachers are not covered by the said notification dated so and so, the present petitioner, though were upgraded, cannot be given the said benefit, and accordingly the Joint Secretary of the Government of Assam, Secondary Education Department, Heights order dated 5/7/2017, that your lordship has gone through that, would do the said benefit. My lord, paragraph 5, it has been submitted that merely because of the petitioners are teaching in madrasa, they could not be discriminated as regard the benefit given by the government to no other non-madrasa teacher, and as such has been submitted that the discrepancy in the policy of the state amount to violation of Article 14 of the Constitution of India. Your lordship may kindly come to para 7 lordship. Having heard the learned counsel for the parties and perusal of material available on record, this court is of the view that this matter can be disposed of directing the petitioner to submit a detailed representative before the respondent number 1 within a week, who shall take a decision as regard the claim of parity sought by the petitioner for upgradation as assistant teacher of madrasa school with graduate scale of pay as given to assistant teacher of non-madrasa school in the intermediate scale who have been given graduate scale of pay to those who are graduate. And your lordship may take the pay paragraph 9. This court is afraid that the said stand cannot be ground for, my lord, I think paragraph 8 will be relevant, lordship, because this is based on the submission of the standing council. However, I am Sharma learned counsel. However, submit that since the court has already rejected the claim of some other assistant teacher serving with intermediate scale seeking similar benefit, the matter cannot be reopened by the authorities. This court is afraid that the said stand cannot be a ground for non-granting graduate scale of pay, which is essentially within the realm of policy decision, and the court has neither decided on the issue of said policy decision nor said that the petitioner are not otherwise entitled for upgradation to graduate scale of pay. What this court had decided in the aforesaid petition is that the petitioner therein are not covered by the notification dated. In fact, Lordship, the court has, Lordship, as this order, basically, Lordship, taking the view that at the time of issuing the notification, that was 1993, the madrasa were not provincialized. That's why in that view, Lordship, that notification only said that high school and higher secondary will cover. And otherwise, the court has directed the authority to consider whether they are otherwise entitled for getting graduate school of pay or not. And after that, Lordship, contempt petition filed, and in the contempt case, Lordship, case 62 onward, and Lordship, I will take only one paragraph. Again, Lordship, case 67. We are, Lordship, afraid that final conclusion arrived at by the special commission is against its own conclusion that all the staff of the erstwhile madrasa shall now be governed by the rules of 2018 with a modified name by omitting the word madrasa. If that be so, the actual situation would be that the present petitioner are no longer the teacher of madrasa school, but they are now teacher of non-madrasa school. From the said point of view, we do not understand as to how their claim for graduate school of pay on the strength of they having their graduate qualification can now no longer be considered. The order of special commissioner itself appears to be self-contradictory. If earlier there was a requirement to decide on the parity between the teachers of madrasa school and teachers of non-madrasa school, after such a repeal of Rule 2016 and the notification dated so and so, such disparity itself would no longer exist if madrasa school would now be non-madrasa school, and that by itself may be a further reason to decide on the entitlement of the petitioner for graduate school of pay on the strength of earlier notification dated 30/12/1993. Lordship, this observation is categorically, Lordship, saying that otherwise these petitioners are entitled to the benefit, to that benefit. In view of the above, the order dated so and so, which was passed in the manner as indicated above, we are therefore view that there is no willful and deliberation violation of order dated so and so. But there arises the requirement of a consequential relief to be granted to the petitioner, and that the special commissioner is required to take a further decision as indicated above, meaning thereby the special commissioner would decide on the entitlement of the petitioner for graduate school of pay, may also take note of that if the petitioner have to be constituted to be the teachers of non-madrasa school, there also cannot be any further reason as to why they are now not governed by the earlier notification dated so and so. In a circumstance where it is an admitted position that the teacher of non-madrasa schools are covered by said notification dated so and so. Accordingly, Lordship, direction to the special commissioner is given to reconsider the matter. Thereafter, that order has been passed. Page 17. That is your Lordship. My Lord.
Raise him after 5.
My Lord. Lord.
Yes.
Presently, Lordship, all the madrasas has been converted to schools. Lordship, I am taking that notification, Lordship. Page 71 is the notification.
71.
My Lord. There are 3 notifications on the same date, Lordship. I will take 2-3 paragraphs. My Lord, notification 71. Page number 71. In exercise of power conferred under provided article so and so, pursuant to the decision of the Council of Ministers in the meeting held so the Governor of Assam is pleased to repeal the Assam Madrasa Provincial Service School 2016. Well, in Roman 2B is important. The existing staff of both teaching and non-teaching of madrasa educational institution, which were governed under the rules mentioned under clause 1 above shall be governed under the Assam Secondary Education Service Rule 2018. Now, Lordship, our service is governing under these rules with effect from the date of commencement of this notification, and their condition of service shall continue without any change in their status and pay, etc. So they are everything will same, and there will be the teacher of lordship now high school, and their service will govern under the 2018 rules. Now lordship pays another notification is page 72 on the same date. This is this notification may lordship skip, and your lordship may take up page 74 notification. Same date, three
This
notifications.
72 and 71 dated same.
Same date. All three notification lordship same date. Page 74 also lordship. And page 74 lordship, your lordship may kindly take page 75.
Yes.
Paragraph 3 lordship.
Mm.
All senior and title madrasas shall be treated as high school with a modified name by omitting the word madrasa. They will now follow the SSLC course curriculum of Seva. The subject of theological aspect like Holy Quran, Islamic study, fiqh, hadith, Israel, so lordship academic shall be put down from these schools. However, Arabic language subject shall continue to be part of syllabus, and all elective subject available in SSLC course shall be added. They will approach Board of Secondary Education Assam to give effect of such modification. The title madrasa may be upgraded to higher secondary school if needed. My lord, our school was our madrasa was senior madrasa, accordingly converted to senior madrasa. It is a high school. Page 76 lordship para 7. I am taking only the relevant part of your lordship. The post of teacher who are teaching theological subject in the provincialized madrasa institution will teach other subject available in the school, their school as per their aptitude. The post of teacher of provincialized madrasa mean for teaching theological subject shall be transferred against other subject available in the school, and all vacancies as and when arises shall be filled up for teaching of subject available in this institution. There shall be no change in the condition of service, including pay scale, seniority, etc. of the existing teachers of provincialized madrasa. My lord, this notification made it clear that whatever pay scale they are receiving, that will continue in the school. Now, your lordship, for a moment, I am taking one paragraph, lordship, in my repetition, page 16, para 22.
Yes.
Just as on perusal of the imprint order dated 22/2020, it appears that authorities are trying to say that FM and MM qualification teachers does not mess with qualification prescribed for a teacher of high school. That was the stand taken in the imprint order. The imprint order further provides that service of the teachers of madrasa education would now be governed by the provision of Assam Secondary Education Service Rule 2018. And as per Rule 14, a teacher should be a graduate in particular stream or subject with BTBA degree from recognized university. Well, this is at present, if any appointment is made, this provision is to be followed. And at that time, lordship, BTBA was not compulsory. The respondent number 1, while considering the case of the present petitioner, has failed to take into account that the present petitioner is having general graduate degree, that is BA with English honors, apart from FM qualification. It is further stated that after conversion of madrasa to school, the petitioner is entrusted with the classes in English subject. It is further stated that petitioner, being graduate in English honors, he is taking classes in English subject since his initial date of joining in the madrasa. He is not the teacher of theological subject. In the second case, lordship, same thing, but he was a general graduate. Now he was taking classes since his lordship insertion of entry in service as assistant teacher, not theological subject. Both the teacher in both the repeat. So, lordship, the ground taken in the imprint order is contrary with not only record, lordship, and this is not sustainable in view of the lordship, the observation made by this honorable court in various orders, lordship. The honorable court, lordship, in 2 orders that I referred, lordship, your lordship has seen that both the orders, lordship, is categorically saying that they are otherwise eligible, entitled for getting graduate skill. They have made very clear, this honorable court, lordship, has made very clear in the order. Only direction part is not given, and that part was left to the authorities. So lordship, petitioners are lordship deserving candidate lordship to get graduate. Now lordship they are teaching in a school lordship. They are taking general subject. On inception lordship in the madrasa itself, they were taking lordship general subject. They are not the theological teacher at all. And they are having BA graduate. That part has not been considered in any of the two order lordship impine order. After passing the lordship, this honorable court order in the first petition, they passed an order during the pendency of the contempt case. After lordship going by that order, this honorable court passed the order in the contempt petition, saying to revisit the matter.
Yes, madam, what is your stand?
After the vacation, Your Lordship,
Why?
because the matter was taken care by NJ Khatuniar, Your Lordship. I have been asked just a few minutes ago that he'd be appearing in the matter, Your Lordship.
So why don't you submit earlier?
After taking long time, lordship. After taking long time.
We'll keep the matter as further.
My lord.
Third, Mr. M. Khan, learned Honorable Court of Petition, and Madam Hearing Day, learned. This is the matter as further on Provincial 6 and 7.
My lord. Problem.
As further.
Item 15.
May I please, Your Lordship? Lordship, the Finance Department was supposed to file an affidavit.
Here, Lordship, in the last page, page 66, Lordship, the stand of the Finance Department has been very specified. I can just take Lordship to the stand of the Finance Department. Here, Lordship, here compensation amount that has been already paid. Lordship, that is the ex gratia amount. That amounts to 3 lakh. Now the petitioner, along with that, is seeking for compassionate appointment, Lordship. That has been discontinued. Lordship made this. Lordship, page 66. I may testify, Lordship. Whereas late Krishna Kanta Das Chowkidar of so-and-so, father of petitioner, was killed by suspected Ulfa on 25/11/2002 while he was on duty. Whereas at that time the petitioner was a minor 14-year-old. Whereas the proposal was received in the Finance Department after a lapse of 19 years on 8/7/2021. Lordship, here now. Next, yes. Whereas in the meantime, the APAC appointment of family so-and-so rule was repealed, and the state government decided to consider enhance the ex gratia amount paid to the next of kin of persons killed in extremate violence to rupees 3 lakhs. Lordship, that amount has been paid. Next paragraph. Where secondary education has already been informed to provide the ex gratia to the petitioner instead of proposing employment of government job. Whereas the scheme for appointment on compassionate grounds of such daughters or near relative of government dies in hand was introduced in 1983. The quota for appointment on compassionate grounds is 5% of vacancies occurring in the year. Whereas it is stipulated that applications for appointment under the scheme in the prescribed month should be submitted within a period of 3 months from the date of death of the person to the respective officer departments under which persons die in harness. Application submitted after 3 months should not be considered. Here is an application which we have received after 19 years. The department had been, maybe it was and next paragraph. Whereas if several years have passed after the death of a government servant, it would appear that on the face of it that the family has managed to support itself all these years and has some subsistence. In such cases, compassionate appointment would not be ordinarily be justified. The compassionate appointment
were introduced so that the family members could sustain themselves since if the king has
No,
died.
at the relevant time, he was minor. His
Yes.
age was 14 years
Yes,
old.
Lordship. Now, Lordship, here what has happened? In the year 2017, the government has already removed the compassionate family appointment, Lordship, because lot of the people
2000?
in somewhere in the year 2017, Lordship, office memorandum has also been issued by the personnel department. Somewhere in
This,
the,
that memorandum is part of your affidavit?
Lordship, we have not filed the affidavit, maybe perhaps the
Not filed.
personnel department has filed it, Lordship, because it was issued by the
Lordship, it's a finance department who's seeking a time for the filing of
Lordship,
affidavit.
we were directed to file an affidavit. If the Lordship directs, Lordship here, because this is a case where a person died during service in a military. For that, the government has now made ex gratia payment. Because Lordship, compassionate appointments and all, the entire purpose of having compassionate appointments or giving out compassionate family pension was to support the family. But there were many cases where, since there was no vacancies available, the family members would not get the appointments for want of vacancy, and the entire purpose of providing that support was defeated, because of which the government introduced ex gratia payment so that instantly the family can support themselves and the government can contribute. That amount has been paid. Now, Lordship, if Lordship goes to the last paragraph also, no compassionate appointments have been given. It has been stopped because the entire purpose of compassionate was to support the family was defeated because there were no vacancies available at that time. So when the vacancies are not there, how can the family members be supported? Because of which the government took different steps, and ex gratia was one of them. Lordship will see the last paragraph now. Page 66 only. Whereas as per the judgment and order dated so and so passed by the Honorable High Court in WPCL and several other connected cases of compassion court, if the applications of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application, all such applications will require no further consideration and must be understood to have spent their force. Whereas it is mentioned that secondary education has already been informed, provide ex gratia or any other fund available as per stipulated term norms of the government to the president instead of proposing government employment. Actually, government employment has been stopped since 2017. So my learned friend over here coming after 6 years looking for the compassionate family appointment, Lordship, is not possible at this stage. That has been barred now. From 2017 onwards, no compassionate appointment has been given. As such, the case of the petitioner has no merit to be considered now, Lordship. That is the specific stand of the finance department. If Lordship directs, then we'll get further instructions and file an affidavit. But as of date, an amount has already been paid to the petitioner. 2021 Lordship finance had received.
When the amount was paid?
Lordship, maybe the petitioner will be in a better position to inform us when they have to.
Maybe the government has a receipt of that.
Of 24 this year? Yes.
Yes,
You
Lordship.
received the amount?
Yes, Lord. Lordship, now our application was prior to the when the act was repealed. Prior to that, we have filed our applications for the appointment on the compassionate ground. So therefore, Lordship may kindly look into our additional affidavit which we have filed for the Honorable Court.
Page number?
Page number 81, Annexure C. Page number 80, Lordship.
Yes.
So, Lordship,
Page number 80 is the office memorandum.
Office memorandum
It was
dated
issued in
29
the
July
year
2013, Lordship. Para 1, Lordship. Lordship, the state has examined the matter relating to giving relief to the families of a person killed in extremist violence for quite some time. Many persons have already approached High Courts for getting relief either under Assam Public Service Appointment of Family Members of Person Killed by Extremist Terrorist Rule 1992 since repealed on 22nd June 2004 or under the guideline issued by so-and-so. The Guwahati High Court also issued direction in many such cases declaring that the provision of 1992 rules will be applicable in the cases where the application for the government jobs were met prior to the June 22, 2004. On several occasions, government has implemented direction of high courts in the individual cases, while the fact remains a lot of similar cases are in the existence awaiting decisions. A detailed examination of the matter was done in the light of a high court's order in the repetition number so-and-so, Sri Dhaniswar Busmudar was a state of Assam where the High Court held that the applications for the appointment to the government post made prior to 22/06/2004 would survive even after coming into force of a new policy in the 2004 Lordship. Lordship, so our applications were prior to the
Lordship, here is only a part of it. Lordship. After, let us have a look at the
Lordship, if they want to file an affidavit, they can file an affidavit and come the bring the statement of the finance department on the record.
Can bring it on record, but Lordship, the application, this notification has been filed by the personal department. So if they are covered or not covered, or whether it is, we are not disputing anything. If it's
That's
covered,
an office memorandum. How can a government?
No, Lordship, that is what we are saying. We are not disputing it. This has been issued by the personal department. So here, application for appointment to government post made prior application by who, Lordship? We have received it on 21. I will survive even after coming into force. Now, as per our instruction, this application is not in existence anymore.
Therefore, Lordship, let them the finance department file an affidavit. Let them file an affidavit.
But I think further clarification will be required from the personal department also.
Third is that?
And Brahma, Lordship.
And Brahma, learned for the, and is that?
Chalia, Lordship.
Yes, Alia, learned for the finance department. And Madam Format for as word. And Madam Therapy, you are for 1 and 3. So solely here Samit said he will file an affidavit.
Lordship, I'll obtain instructions and if required, we'll file an affidavit. Lordship, will say instructions.
Lordship, let them file an affidavit. Lordship.
No, there was earlier direction to file a affidavit.
Yes, Lordship, on the
You file an affidavit. He will obtain necessary instruction and file an affidavit in this regard and price for granting him some time. Here is allowed.
Last chance may be given, Lordship.
No, last chance, Lordship. Here it's a 23 matter, Lordship. We have already paid an amount regarding.
Okay, Bobby.
First 19 years they have come.
22nd.
Yeah, 16.
I was appointed as the assistant teacher in Alisiga Kabolo MA School in the district of Lakhimpur, Lordship, in the year of 2003, Lordship. By appointment letter dated Annex R1, Lordship. Case number 21, Lordship. That is the managing committee has initially issued the appointment letter.
Pardon?
We will file our affidavit.
You will file.
Because
when?
This is not the first round of litigation. This is several round of litigation coming up.
That's
And
all
now
right. That
petition-
does not mean that
no,
file your affidavit.
No, Lordship, we will file our affidavit because here, Lordship, pursuant to the earlier round of litigation, if you, Lordship, page number 84, in compliance to the earlier round of litigation, this order was, executing order was passed. Page 85. Now, the petitioner here telling the provincialization of the private respondent in terms of the 2011 Act in 2013. And this order has subsequently been order has been passed in compliance to the earlier round of litigation. It's for it. And there was no recommendation of the petitioner from the district to the committee. Therefore, Lordship, we have to file our affidavit. And this particular order has not neither been challenged by the petitioner. This is a subsequent development.
No report to Senate. I am only challenged this order. This order has been challenged, Lordship. And prior to this, Lordship, earlier litigation has been filed, wherein directed the
1 of 2015 was withdrawn by the petitioner with the liberty to approach the appropriate forum.
accordingly we
And accordingly, the petitioner approached the appropriate
approach,
forum,
yeah.
and this speaking order was
the order has been passed.
order has been.
This speaking order itself says that the 2013 11 Act has already been
struck
down, Lordship. So this matter has been placed in the present Act as per 2017 Act. So we are not entitled to get such provincialization, Lordship, as because only 3 posts are sanctioned as per the new Act, Lordship. But Lordship, my case is covered by the as per the new earlier Act 2011, Lordship. As because Lordship, earlier litigation has been filed, wherein court itself directed the respondent authorities, Lordship, to inquiry. Accordingly, inquiry has been conducted, Lordship, page number 63, Lordship. Kindly be perused. Page number 63, Lordship. And this inquiry order has been passed by the district elementary education officer, then forwarded to the director of elementary education, Kahanipara, Lordship. This order itself says that in compliance of Honorable High Court order dated 4/8/2014, passed in WPC number 205413, in the matter of Horen Khan versus State of Assam, headed by Honorable Justice B.K. Sharma, the District Redressal Committee has re-examined the necessary document of the petitioner, Sri Horen Khan, as well as the respondent number 7, Mohori Pegu. Respondent Sri Mohori Pegu has joined this school as an assistant teacher and continued to render his service thereof. However, on 18/1/2006, due to accident, respondent remained absent in his duty till the year of 2007 on unauthorizedly. Medical documents which were produced are not acceptable. Again, since 2008, Sri Mohori Pegu has been teaching in the school. Petitioner Horen Khan had joined in the school, in this school, as an assistant teacher on 23/2/2003, and since then he continued to render his service till the year of 2013, but has remained absent since 2013, as clear from the statement made by the petitioner as well as respondent number 7. The headmaster also filed a statement in this regard. Statement are enclosed along with the minute of proceeding. Decision is taken to forward the matter higher authority for the consideration and appropriate action. Decision. So, Lordship, till then, Lordship, appropriate authority has not passed any appropriate order, and this order has been passed in compliance of Honorable WPC case number 205423, Lordship. I did order dated 4/8/2024, Lordship. 14, Lordship. This order can be produced. Page number Annexa 11, page number Annexa 11. Page number 59, Lordship. This is the Honorable Court order as agreed to by the Learned Council for the parties. This writ petition is disposed of directing the Director of Elementary Education to cause an inquiry by the appointed committee as per the provision of the Act of 2011 and the notification dated 30/1/2013 for towards resolving the dispute raised in the writ petition. Needless to say that opportunity of being heard shall be provided to the parties involved. Let the process be undertaken and completed expeditiously as possible, preferably within 2 months. Accordingly, Lordship, I was duly appeared before the authority, Lordship, and the Block Elementary Education Officer itself prepared a report, Lordship, that is also I have annexed, Lordship, as Annexa 10, page number 58, Lordship. Kindly be perused, Lordship. This order has been prepared by the Block Elementary Education Officer. Again, he submitted the same before the District Elementary Education Officer. In this order, Lordship, itself stated that, Lordship, relevant page number 53, Lordship. Relevant page number 53, this order, Lordship. Annexer 10, relevant page number 53. Herein stated that is not found assistant teacher. It is seen that the post of first assistant teacher of Mr. Mohori Pegu is placed as the first assistant teacher in the teacher attendance register, but in the attendance register his signature is not found. The completed year, it is seen that 2006 Sri Jagat Dole has been posted as the first assistant teacher as found from the documents of 2006, but from the attendance register of 2006, it is found that the Sri Horan Khan has put signature as the first assistant teacher. Again on 2007-8, he is allowed to sign as the third assistant teacher. Again on 2009, it is found that Mr. Khan is allowed to sign attendance register as the fourth assistant teacher. And again on 2010, it is found from the records that he has put his signature in the attendance register and the third assistant teacher. During my inquiry dinner on 2011-12, when I asked headmaster to produce the teacher attendance register, he could not able to produce, and till date he has not been produced. Your Honor, it is true, as found from the inquiry of the document record attendance register and signature of Sri Horan Khan may be considered as the regular assistant teacher. So, Lordship, this is the report prepared by the Block Elementary Education Officer, which is submitted before the District Elementary Education Officer, wherein stated that the Horan Khan, myself, Lordship, the petitioner, attendance, register, and signature, Horan Khan may be considered as regular assistant teacher. So, Lordship, instead of me, Lordship, my grievances is that the Mohori Pegu, who is the respondent number 7, who has been provincialized, Lordship, as assistant teacher, apart from me, Lordship, as aggrieved, Lordship, earlier litigation has been filed, and thereafter, Honorable Court has granted stay order, Lordship, and till now, Lordship, this post has been remained vacant, Lordship, and stay order has been granted, Lordship. Accordingly, Lordship, another round of litigation, Lordship, ruling directed to me to approach before the Director Elementary Education Officer Kahanik Para, Lordship. Accordingly, and by compliance with the said order, Lordship, I have filed a representation before the authority, and subsequent states, Lordship, the authority has passed this order, Annexer 84, Annexer 19, page number 84, Lordship, wherein clearly indicated that, so may I please to read this order, Lordship. Order. Read Honorable Court order dated Chuancho passed in WPC number Chuancho filed by the Horan Khan versus State of Assam others. Finding as reported by the Director of Elementary Education Assam DEO Lakhimpur has submitted proposal for provincialization of service of following teachers against Alisiga Khabolu Janajati ME School with recommendation of DSC Lakhimpur. Name of the school, Chuancho, Lordship. There are the 6 number of post, Lordship. One is the 4th grade employee. Apart from 4th grade employee, 5 number of posts has been provincialized, Lordship. Now Mohori Pegu post has already been dropped by compliance of this Honorable High Court order. So, Lordship, the said proposal was verified by DE Assam and submit the proposal to the government for creation of posts. Accordingly, government has sanctioned 5+1 posts again. Alisiga Khabolu Janajati ME School, and DE has issued provincialization order keeping 1 post vacant due to court case in WPC 2054-13 filed by the Horan Khan. The name of the petitioner was recommended by DSC. Was not recommended by DSC Lakhimpur for provincialization of service as per Act 2011 as amended 2012. Thereafter, Sri Horan Khan filed another case in WPC number 451015. As such, the service of Mohori Pegu could not be provincialized. The Honorable High Court passed an order dated 3/2/23 in WPC number 451015, Horan Khan versus SOA, with a direction to the writ petition dismissed as withdrawn with liberty to approach the appropriate forum with appropriate petition. Subsequently, Mohori Pegu has submitted an application to DE Assam for provincialization of his services 80. Therefore, petitioner of the instant case, Sri Horan Khan and Sri Mohori Pegu, were asked to attend the hearing on so in the office of Chamber of Secretary School Education Department. Decision. In view of the above fact and finding, it is observed that Assam Bhensa Institution Provincialization of Service Act 2011, amended in 2012, was struck down by Honorable High Court order dated 23/9/2016, passed in WPC number 319012, and hence the matter was considered under the
One post is lying vacant.
Lordship.
One post is lying vacant.
Yes, Lordship. One post is lying vacant, Lordship. Even Lordship, the decision itself says that, Your Lordship, that the Honorable High Court struck down the earlier Act, Lordship, 2011, Lordship. Therefore, my case has been considered in the Act in the year of 2017. So, Lordship, kindly be perused at the Act of 2017 itself says that, Lordship, this Act, Lordship, under section 2 ZA, Lordship, 2 section 2 ZA, Lordship. This Act clarified that Bhansar ME school, including Bhansar ME Madrasa, means upper primary school, imparting education from class 6 to class 7 and established by the people of the locality prior to 1/1/2006, which has received recognition from the competent authority on or before 1/1/2006, and captured in this code up to 2009-10, and whereof the service of the teachers have not been provincialized under any act enacted by the state legislature so far. Other hand, Lordship, section ZD, Bhansar Educational Institution means and includes Bhansar Degree College, Bhansar Higher Secondary School, Bhansar Junior College, Bhansar High School, Bhansar High Madrasa, Bhansar ME School, Bhansar ME Madrasa, Bhansar Upper Primary School, and Bhansar Lower Primary School. But my case is, Lordship, my school has already been provincialized, Lordship, but my post has been dropped. Earlier, Lordship, several round litigation has been filed, wherein stay order has been granted. So, Lordship, earlier judicial order has been passed, which is prior the order of the division bench order, which wherein the struck down of the act. So, Lordship, my case has been considered, ought to have been considered prior Act 2011, not the Act of 2017, Lordship. Well, in the judicial order itself is there, Lordship.
That page number, that order.
Annex 11, Lordship, page number 60, Lordship. In pursuance of the said judicial order, Lordship, I continued page number 58, Lordship, Annex 11, Lordship.
Where stay is granted?
Lordship, this is the final order, Lordship. Prior this, Lordship, another stay order has been granted, Lordship. Page number 66, Annex 14, Lordship. Honorable Justice Rishikesh Roy, Lordship, wherein state are imposed proceeding. Last column, Lordship, can be. It is last number of 2 lines from top, from lower, Lordship. In the interim, provincialization benefit to the respondent number 7, Mohori Pegu, should not be granted on the strength of the impugned notification Annex 10.
Yes, Mr. Sharma.
Page number 85, the decision.
Page number 85. Yes.
In view of the above facts and findings, it is observed that the Assam Provincialization Provisional of Services Act 2011 was struck down by the court by order dated 29 and hence the matter was considered under the Act of 2017, wherein the Act permits only 3 teachers. Section 3111 of the 2017 Act provides for 3 teachers.
No, his case is prior to that order, no?
But then, Lordship, now 2011 Act has been struck down, so there is no scope for provincialization in terms of the, if at all The provincial has to be carried out, it has to be carried out in 2017 Act.
His case was prior to step down of the earlier act.
So Lordship,
Subsequently this order, Lordship. Now ultimately, Lordship, the last round of litigation was 4510/2015. That has been disposed of in 3/2/2023, wherein the petitioner has withdrawn the writ petition with a liberty to approach the appropriate forum. This exercise has been carried out in 2023, Lordship. So in that matter, Lordship, we will file the detailed affidavit, Lordship, for 3 weeks time. Because last order, Your Lordship, in 4510/2015. This order was passed on 3rd February 2023, wherein the petitioner has withdrawn the application with the writ petition with the liberty to approach the appropriate forum. And the petitioner approached along with another applicant, the appropriate forum. And appropriate forum, the secretary passed this order. And now this order has been challenged by the petitioner. So, Lordship, Lordship allowed 3 weeks time, we will file affidavit.
although division bench has struck down the said act, Lordship, but another review petition has been filed by the government itself, Lordship, and same was registered as the WPC number of review petition number 1767/16, wherein division bench clarified that, Lordship, the any action which has been remained, Lordship, same has
Initiated
been
in
set,
earlier,
Lordship.
while the earlier act was in
Struck down any action, Lordship, any grievances of any person, Lordship, the same has been safe, Lordship. Review petition, Lordship, 167/16, Lordship.
Where is that order?
This order is available with me, but Lordship,
not part of this writ petition.
Not part of this writ petition. Subsequently, Lordship, when I properly studied and I came to know that the review petition has already passed an order wherein my right has been protected.
And what is the finding of that writ petition, review petition?
There is Lordship 2017 2 GLR 749, Lordship. That is also GLR.
What is the finding
Entire
of that
page
writ?
is actually not available with me, Lordship. Same has been some black and white, remain as black and white, Lordship. The review petition 167/16. I don't know. In WPC number 5825. One 67/16. Pattinam, the state of Assam. The state of Assam, Bimol Kutum. Oh, 5/12/2026. Judgment date 2nd January 2017. Judgment dated 2nd January 2017.
Order is not available. You find out a certified copy.
Lordship, certified copy. Yes.
Keep it as part.
Part,
Mr.
M. Soikia, Your
M. Soikia, learned for Sir Sorta. Learned for this. 13th part, list the matter as parted on
22nd January.
22nd January. In the meantime, Mr. Sorta, learned counsel for the respondent for it, may file affidavit in opposition to advice.
I am deeply obliged.
What is that order on that day?
Lordship.
Item 17.
Lordship, here instruction is awaited, Lordship.
No, you were sending your strength. On the other day, you submit that you have received instruction.
It was not complete instruction because this period, particular period was he remained unauthorized absent. Prior to that, he was allowed medical leave on 3 phases, Lordship, and he is admittedly he is getting his current salary also. It is only the part of that period of July 2019 to January 2021. After availing the medical leave in 3 phases, thereafter he did not join. He remained unauthorized absent for that particular period. Otherwise, that leave period was also regularized. Only this July 2019 to February 2021, this particular period, he was neither, he applied for any, the Lordship will kindly see the report from the Lordship will kindly peruse page number 35.
Yeah.
Paragraph 2. Serial number 2. The incumbent was getting his salary regularly from 8 to 1996 onwards till 31/12/2017. From January 2018 onwards, he has availed PB league salary till 21/5/2019. 6 pages, sorry, 6 pages. With sanction from PI official Golaghat. After 21/5/2017, he did not join in his duty till 7/3/2021. After that, he joined in the school duty on 8/3/2021, and from that day onwards, he is getting salary regularly till August 2021. Now, what is the next page? Penultimate paragraph. Further, it may be mentioned that during this period, from 7/6/2019 to 7/6/2021, he neither departmentally applied for leave or leave salary nor joined in his school duty. In lieu of that, he is repeatedly sending legal notice claiming the arrears salary for the period to advocate. So he has neither applied for it. He remained unauthorized up to this particular period only. So we'll file our application here.
So file your affidavit on next date. Third Mr. or open for the for the elementary education department. Mr. Sornal submits that he has not yet received the instruction. And press for granting in some order. Here is allowed for the last time. Please the matter on
28/20.
as per heard.
Obliged. Item 18.
So in this case, the respondents today they have filed an affidavit wherein they have withdrawn the impugn order. Copy of the affidavit is served upon me. They have withdrawn the impugn order by an order dated 17 December 2024. And also they have directed the governing body to submit a fresh proposal for
This petition become infectious then.
the governing body has to take a decision as regards the other prayer. As regards the impugn order that has been withdrawn. If my lord may kindly
the impugn order is
withdrawn, that is gone, my lord.
Uh,
The other issue as regards regarding the promotion of the petitioner to the post of head assistant. For that, the director has written a letter to the principal Hendrick College, my lord, that you send a fresh proposal. It can be closed off, my lord. It's closed off, my lord. This is a copy of the affidavit today furnished. The impugn order which I had challenged was 6/12/23 that they have withdrawn. 6/11/23. And the second was regarding taking a decision as regards the promotion to the post of head assistant. For that, the director has written a letter to the Hendrick College principal that you send a fresh proposal.
Yes, Mr. Obama.
close because we have already the petition has gone to the Supreme Order is withdrawn.
And as regards the second, my lord,
We have already
the college has to send the proposal to the
director of heirs.
2 and 5.
4 and 5.
4 and 5. First, Mr. Count Learned Counsel for the petition. Mr. D. Learned. Standing Counsel for the respondent number
1, 2, and 3.
1, 2, and 3. And Mr. U.P. Soliha, Learned. Standing Counsel for the respondent number 4 and 5. 4 and 5. Mr. Soliha, Learned Counsel, no, sorry, Mr. Count Learned Counsel for the petitioner submits that he has been served with a copy of the affidavit filed by the respondent number 3, and in the said affidavit one order has been enclosed. Order dated 17 December 2024 has been enclosed along with a letter dated 17 December 2024 addressed to the principal Handicap Guards College, Guwahati. And the impugned order in this writ petition has been withdrawn by order dated 17 December 2024. And the principal of the Handicap Guards College was asked to take a decision regarding leave period of the petitioner with effect from 1/1/2002 to 7/10/2006 as per judgment and order of this court dated 6/12/2022 in WBC number 1697 of 2015. Mr. Town Learned Counsel for the petitioner submits that as the grievance of the petitioner has already been redressed, this petition may be closed. Accordingly, this petition stands closed.
One more issue, my lord. As regards the resolution, they may send a resolution for as regards the second letter, my lord, at 17/12/24. The time frame may be granted to the college authorities to send a letter, my lord.
To submit the proposal.
To submit a proposal, my lord.
To submit the proposal.
Because my lord may kindly peruse, earlier they had sent a proposal, my lord, at page 143. Of my writ petition for regularizing the service of the period. On this regard, the director has said that it is not specific.
Petition within a period of 1 month from the date of receipt of certified copy of this order. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 5 within a period of 1 week from today.
Item 19.
Here, Lordship, in this matter, Lordship, we have filed a affidavit this morning, Lordship. So that has not been on record. Filed this morning. Provided them.
My lord, I need some time to file the reply.
Reply.
My lord, matter will be fixed in the February, month of February.
Month of February. Okay. Third Ms. P. Barman, Learned Counsel for the petitioner. And Mr. Upamunya, Learned Standing Counsel for the respondent number
1, 2, and 3.
1, 2, and 3. And respondent number 5. Number 5. Mr. Upamunya submits that he has filed affidavit in opposition today morning only. And Ms. Barman, Learned Counsel for the petitioner submits that she may be granted some time to file a reply. Here is accordingly allowed with the matter in the first week of February. So as to enable Ms. Barman, Learned Counsel for the petitioner to file affidavit in reply.
The time and again, Lordship, the respondents are taking time, Lordship, for filing affidavit. Several times. On the last occasion also, Lordship, I met them outside, Lordship, but they didn't appear here. And wait for time, Lordship, for Zoom. Lordship,
Yes, Mr. Sharma. Pardon?
Lordship, all
SSA.
Lordship, SSA, Lordship, elementary education, as well as the DC also needs to file an affidavit, Lordship, Deputy Commissioner, Lordship, respondent also. DC had initially done the part, Lordship, second line of litigation, there was an order from the Honorable Court that the petitioners who were working in a school, Lordship, they were not allowed to continue. As per the direction of the Honorable, our Honorable Court, Lordship, he made an inquiry and provided some directions to his juniors, Lordship, that is at page 66, Lordship. Petitioners were serving as cook and helper in a school, Lordship. Cook and helper for a school, in a school, Lordship, and appointed in a regular manner, Lordship, but they were not allowed to continue their job. So I approached this Honorable Court, and the Honorable Court passed an order, Lordship, that some inquiry should be made by the Deputy Commissioner and pass appropriate orders. And page 67 is the report, Lordship. Last para, Lordship, in view of the above, I'm
Directed to reinstate. So
Lordship.
they say directed to reinstate you.
Reinstate, Lordship, and continue the job and pay the honorarium, Lordship. Now they have been in the second line of litigation. I have prayed that I am not paid the honorarium, as well as I am not been allowed to continue. So instructions were called for them whether they are still working and honorarium were paid. That is the order of Lordship 25-6, Lordship.
Page number.
No, Lordship, Honorable Court's order, Lordship. 25-6-24, Lordship. They were directed to file affidavit, and earlier also, Lordship, they were directed to inform this court whether they were reinstated and working and whether they were paid the honorarium, Lordship. Nothing has been done, Lordship. Nothing is coming from them. And I can go nowhere, Lordship. How do I know what their instructions will be? Otherwise, I could have prayed for admission hearing, Lordship. Without their instruction, Lordship, I cannot pray for that also, Lordship. And this has been going on from 2020, Lordship.
So, Mr. Sharma, file your affidavit.
Midday meal. That midday meal is handled by the SS, and their appointments and all are taken care of by the SS.
Who is for SSA?
Affidavit will be
Mr.
important. Affidavit from the SSA.
Who is appearing for SSA? On behalf of Mr. Yes. When? After?
Lordship, this
So,
has
we
been
are
going on,
telling you
Lordship.
last time. No further chance will be given to you. We will, otherwise, we will decide the petition. Third, Mr.
M. Bhagavati.
M. Bhagavati, Learned Counsel for the Petitioner, and Mr. P. Sharma, Learned Standing Counsel for Elementary Education. And Madam A. Portakur, Learned Counsel appearing on behalf of Mr. P. Nail, Learned Standing Counsel for SSA. Having heard the submission of learned advocates of both the parties, last opportunity is given to the Standing Counsel for SSA to file the affidavit. List the matter on
24th January.
24th January. In the event of failing to file affidavit on that day, the court will proceed to hear and dispose of this petition on the basis of materials placed on record.
Madam, 24.
May please, Your Lordship. Lordship, last occasion, Lordship, this honorable court directed to take fresh step against the respondent number 3, 4, and 13, Lordship. So, Lordship, I may be allowed to take dusty service in regards to the respondent number 3 and 4, Lordship. And regarding the respondent number 13, Lordship, I have taken step only on today, Lordship.
13.
Yes, Lord.
13. What's your good name? Yes? Yes, after it. 13, 15, 16, 17. 4. 4 response. Heard, Mr.
M. Das.
M. Das, Learned Counsel for the petitioner. And Madam. Respondent number 6. 6A2. 6M. F. 6F and 7. Your good name, please. You are appearing on behalf of NH. Yeah. Learned Counsel. And Mr. Afridi for respondent number 13, 15, 16, and 17. Not 14. Who is for the 14? Respondent number 14. The learned counsel for the petitioner, the appellant submits that he may be granted some time to effect service of notice upon respondent number 3 and 4 by the stimulus. There is accordingly allowed after effecting service upon respondent number 3 and 4 by the stimulus. The counsel for the petitioner appellant shall file an affidavit before this court. Please the matter after 4 weeks or 2 weeks.
4 weeks, that's it.
4 weeks.
We have not copy of IE. There is an IE. We have not.
I will put it. I'll check.
I is disposed of.
I'll dispose of that. 750. 750 already.
So I is not yet disposed of.
I number 750.
Oh, 750.
Lordship, it is the substitution, Lordship. They are already appeared, Lordship. They had already appeared, Lordship.
Okay. In the IA, you become same thing. The learned counsel for the respondent number, you have for respondent number 68267 submits that he has not been furnished with a copy of the interlocutory application. The learned counsel for the applicant submits that he will furnish a copy of the application during the course of the day.
Yes, sir.
Place the matter on after 4 weeks.
Organized, Lordship.
25.
May it please your lordship. Lordship, as per office note dated 21/8/2024, service is not complained upon respondent number 9 to 15.
9 to
15, your lordship.
9 to 11.
9 to 11 and 12 to 15, your lordship. Kindly allow us to take fresh steps upon those respondents.
Heard Mr. S. Dotto, learned counsel for the appellant, and Madam Ayala for respondent number 1 to 7. 1 to 7. Mr. Dotto, learned counsel for the appellant, submits that he could not take scale of respondent number 12 to 15 and prays for granting him some more time. Here allowed. Let the matter after 4 weeks. Step upon respondent number 12 to 15 shall be taken within a period of 2 working days from today. List the matter after 4 weeks.
Okay, Mason.
Item number 26 and 1 of production list.
May I please your lordship. My lord, in this matter, a connected IA has been filed, my lord, for including the present director of higher education as a party respondent, my lord. We filed for
Third is that
PH score, my lord.
learned counsel for the applicant. And Mr. Upomanya for respondent number. Now for contemptor number 2. Yes.
Notices will have to go.
And this is only for implement.
I have no objection to this.
My lord,
This
I'll serve you my
interlocutory
copy, my lord.
application under Order 1, Rule 10, Question Bracket 2, read with Section 151 of the Code of Civil Procedure, is prepared by the applicant for implement of the present incumbent as respondent in the contempt petition, as contemptor in the contempt petition number
490, my lord.
490 of 2022. Mr. Upomanya, learned counsel appearing on behalf of respondent number contemptor number 2 submits that he has no objection in the event of allowing the present application. However, Mr. Upomanya submits that notice may be issued. Having heard the submission of learned counsel for the counsel for both the parties, this court is inclined to allow this interlocutory application. The present incumbent, namely, what is the name?
Pomi Bhutala.
Pomi Borua, Director of Higher Education, Assam Kahlipara, being pleaded as contemptor number 2 in the contempt petition number so and so. In terms of this IA stands closed. The petitioner shall take necessary steps for correction of the first title of the contempt case number 490 of 2022. And thereafter the recessal is the matter for the court.
Much obliged, my lord.
Yes, Dr. Porrick.
My lord.
27.
Please, your lordship. Appeal was already admitted. Respondent number 1 has entered appearance. As regards respondent number 2A to 2D, as per office note dated 28/2024, respondent number 2A is expired and 2B to D has been served, your lordship. There is no question of substitution because the legal heirs are already there on record.
But our information,
Jitan Burman has also expired.
and we have not received any IA copy. Only memo of second appeal. There is an IA also that has not been served.
IA is for what purpose?
Regarding execution, I find on the order regarding execution. We have no information.
Staying execution.
Execution. I have no information in this regard. First, I need to direct my learned friend to start a copy of the IA. There is an order of the appearance of the other side that IA will be further considered.
In IA, you take down heard Mr. Mukherjee, learned counsel for the applicant, and Mr. Bhuya, learned counsel for the respondent number. Respondent number 1. Mr. Bhuya submits that he has not been served with a copy of this interlocutory application. Mr. Mukherjee, learned counsel for the applicant, undertakes to furnish a copy of the IA to Mr. Bhuya during the course of the day.
No.
List the matter after 4 weeks. In the main petition. Office note dated 28/8/2024 indicates that service report upon respondent number 2A to 2D has been received. And as per the service report, respondent number 2A suffered demise. And respondent number 2, and notice upon respondent number 2B, 2C, and 2D has been served. Are you appearing for remaining other respondents?
No.
But none appears today. No, but the said respondent remain unrepresented today.
I am the plaintiff.
Mr. Mukherjee, learned counsel for the appellant submits that respondent number 2A has been represented by the other
legal heirs.
And as such, implement of the legal heirs of respondent number 2A is not required. In view of above, it is provided that Procedural list the matter for hearing.
I'll serve the copy. And appellant number 1 has also suffered demise, Your Lordship. Appellant number 1 and the legal heirs are already the other appellant. As such, I pray for striking out the name of appellant number 1. Yes,
Appellant number 1. Mr. Mukherjee, learned counsel for the appellant further submits that appellant number 1 also suffered demise. And as such, his name may be struck off from the area of this appeal. Here is accordingly allowed. Procedural do the needful in this regard. List Dr. Horrocks.
28.
May it please your lordship.
Yes.
My lord, last order may kindly be seen, my lord, 2711.
Yes, you are appearing for respondent.
Respondent number. Respondent number 1. Now, one sole respondent is there, my lord.
Four.
Class C.
You have for 1.
Not only one respondent is there. Class C, my lord. I am appearing for sole respondent.
Also, sole respondent. Okay. Okay.
But in this case, my lord, you may kindly peruse page 28, my lord. Joint petition they have filed before the principal judge family court, my lord. Only one issue is there, my lord. The respondent needs a permanent alimony, my lord. Otherwise, she has no objection regarding to his prayer of divorce, my lord. Permanent alimony she required, my lord. And she is a 68-year-old lady, my lord. She has no one to look after her, my lord. So she wants a permanent alimony amount of rupees, my lord, 50 lakhs. As per instruction I have received, my lord. In addition to the, my lord, terms and condition, my lord, that lordship will file case 13, my lord, judicial separation decree, my lord. In addition to that, my lord, if the petitioner pays 50 lakhs to the respondent, my lord, he has no objection regarding to his prayer of divorce, my lord. That's my humble submission to your honor.
My lord, actually earlier they have filed an application for judicial separation. Originally filed divorce, but as per the advice of the middleman, they converted the application to judicial separation. Then in judicial separation also there was a mutual agreement between the parties, my lord. That is, and terms and conditions were also given. Your lordship may be pleased to see at page 15. Last, page 15 last, that the respondent will reside.
Mr. Kolita, what is your pair in this CRP? What is your pair in this petition?
My lord, this compromise petition may kindly be directed to dispose of by the family court, my lord. That was your lordship at page 11, my lord.
Page 11.
Page 11. It is therefore prayed that your lordship may be pleased to issue a rule calling upon the respondent to show cause, if any, by the respondent, and after hearing the parties, be pleased to direct the learned family court number 1, Guwahati, to dispose of the case within a period of 3 months from the date of the order of this court. Alternatively, this honorable court may be pleased to pass an order of dissolution of marriage by a decree of divorce as per the compromise petition Annex 30. My lord, at this stage, my lord, if my learned friend agrees, my lord, let that petition be directed to dispose of by the family court number 1, and if there is any question of alimony and other things, my lord, then party may have or agree to pay 50 lakhs, but she have to vacate the house. Already she was given a flat, half portion of the on rent, cash 10,000 rupees per month. That's what given in the, as per the earlier order, my lord. So if she demands again money, then one time amount may be taken and she will go out from the house. Otherwise, my lord, according to this petition, my lord, that she will remain there as per the conditions of the original judicial separation application, my lord. That actually, if your lordship want to decide the divorce petition itself here, my lord, then this condition will come. Otherwise, my lord, let the matter go. The date is fixed on 6th of January, my lord. This petition may be directed to dispose of immediately.
In terms of, my lord, paragraph 2 of joint petition, my lord, permanent alimony is, my lord,
At
mentioned.
page 28, my
No,
lord.
you raise the issue before. Definitely. That court will.
There is they have stated, but alimony is to be decided fairly and properly by the honorable court. Let them decide, my lord. Otherwise, my lord, this application will not be decided for a long time again. There are now issues frame, evidence, their evidence, thereafter question of appeal and other things will come. Already, my lord, from 2011, already 13 years passed. Original dispute started 2011, my lord. FC Civil 189/11, my lord. And directing, my lord, this
You
petition
admit that one compromise petition is pending before the trial court.
Yes, my lord, that compromise was not pending, my lord. After that compromise petition, my lord, case was proceeded, my lord. That compromise petition was not follow up, my lord. After that, the learned principal, the family court started the matter proceedingly, my lord. That's the provision of law, my lord.
Actually,
now,
that
this is fixed for evidence for PW.
What happened to that compromise petition?
That compromise petition was not considered by the principal judge.
Why?
Not any instruction in that regard.
that was signed by both the parties, my lord. You will also may be pleased to see page 29, my lord. It is their signature is there fully.
Order dated?
No, page 29, my lord. That compromise petition, my lord. That was signed by both the parties before the mediator, my lord. And mediator sent it to the principal judge, my lord. But principal judge failed to consider this application and proceeded the suit. That was the problem, my lord. It was signed by both parties, my lord. Apurva Hazarika, Deeposri Hazarika. So my humble submission before your lordship that an observation may be given that this petition will dispose of on 6/1/25, my lord, and no further date and other things will be given. Because my lord, only problem is this, my lord, his client did not appear before the court. Otherwise, it would have been disposed of long back. He failed to appear. Advocate appear, my lord.
Are representing the party in the trial court?
This, if your lordship, this observation.
My lord, if due to my illness, my lord, sometime I not able to present, my lord, then I file petition, my lord. Otherwise, I am regularly present, my lord. But me kindly
Yeah, advocate is present. My lord,
8 years old lady, my lord, having so many old ailing disease, my lord. No one is here to look after her, my lord. Even she can move properly, my lord. So old lady, my lord.
And directing this, my lord, this petition can also be disposed of because we have no more pair.
Okay. Heard Mr. P.K. Koleta, learned senior counsel, assisted by
K. Talukdar.
Mr. K. Talukdar, learned counsel for the petitioner, and Mr.
S.A.B. Kabir, my lord.
S.A.B.
Kabir.
Kabir, learned counsel for the respondent. This paragraph number 2 of order dated 27/11. Having heard the submission of learned advocates of both the parties, it is provided that the learned principal judge, family court number 1, Kamrup Guwahati, shall dispose of the petition number 104 of 2023 dated 19/7/2023. But the problem is that we cannot direct the courts below to dispose of a petition within a definite time because of the decision of the Supreme Court in the case of Allahabad High Court Bar Association versus State of UP.
Otherwise, my lord, again 3 months, date will be given after 3 months, my lord. So,
So what we can do, we can request the court to dispose of the petition as soon as practicable.
Actually, as soon as practicable, but specific time may be given,
No,
my
no,
lord.
no.
Otherwise, my lord,
No. What happened thereafter, after the judgment of the Supreme Court,
As early as
one
possible,
of the High Court has directed the trial court to dispose of the petition within a time frame. But the Supreme Court has
as
deprecated it.
early as possible, my lord. As early as possible.
As soon as practicable. As soon as practicable. In terms of about this CRPIO stance, close stance disposal.
$29.
Please, Your Lord. Actually, as per office note dated 16/12/2024, Lord. Service is awaited, Lord.
Heard, Mr.
M. Das.
Learned Counsel for the petitioner. Office note dated 16/12/2024 indicates that neither ID card nor unserved notice in respect of the sole respondent received by the regime. What to do? You want to take
Await,
passes?
Lord.
Passes.
No, Lord.
Wait,
Await,
wait.
Lord, because we have
So,
taken step on.
Registrar list the matter after 2 weeks, awaiting
Yes.
service report upon the sole respondent.
Lord.
Item 30, sorry, 31.
You are for respondent.
I'm for the but before the year 2020. Then again after the year 2020, thereafter they have filed the file for delay. So, got to go to the order dated 2/23. None
2/20.
20 again January, second February.
When passed in the main petition.
Yes.
RSA.
Yes. One fact.
Sixteen to 23.
2/20.
2 to 23. There is no order.
I got copy of it.
Yes, you can get.
I'm reading it.
Keep the copy. How many eyes are pending? But this date has been corrected later on. 16 to.
Yeah.
Okay, let us wait for another day. If on that day the
I may
applicant
be
is in
allowed to
absence.
file the objection.
Pardon?
I may be allowed to file objection.
Okay. None appears for the applicant on call. However, Mr. Learned Counsel for the respondent opposite party is present. List the matter after 2 weeks. In the event of subsequent non-appearance of the applicant, appropriate orders will follow. The learned counsel for the respondent submits that he may be allowed to file objection in this petition. Here is allowed. List the matter after 2 weeks.
32.
May please your lordship. Lordship, in this matter, it is in the verge of amicable settlement. So
Pardon?
kindly, there is a chance of amicable settlement in this case. So we need some time to obtain instructions from the party. So kindly a date may be fixed on next date we may withdraw.
You are for?
Petitioner.
Why this IA is filed? I number 789. Whether you have taken any step as per order of this court dated 29/4/2024?
Steps taken.
You have taken. Pardon me, your good name?
E. Borua.
Learned counsel for the applicant. None appears for the respondent on call. However, office note dated 27/6/2024 indicates that one learned counsel entered appearance by filing Ukalatnama for the sole respondent. The learned counsel for the applicant further submits that there is a chance for reconciliation between the parties. Chance for amicable settlement between the parties, and she may be granted some time to obtain necessary instruction. Where is accordingly allowed, place the matter after 2 weeks.
Deeply obliged.
33.
May it please your lordship. The IA is filed for correction of typographical error in the cost title. The father's name of the respondent number 2 was wrongly typed.
Any objection?
They were directed to take step by way of document, and to that effect, they were also directed to file an affidavit.
You are appearing for?
Respondent, opposite party number 1.
1.
Regarding 2, as we were not being able to take steps because the name was wrongly on the last occasion when the matter was listed on 3/6/2024, it was discovered that the father's name of the respondent number 2 was wrongly typed. As such, before taking steps, that needs to be corrected, and we were granted the liberty to file an appropriate petition.
So his name is reflected as
Name
Dandeswar Borua.
Dandeswar Borua.
It ought to have been
Radha Mohan Sahani.
Radha Mangal Sahani.
Yes, late Radha Mohan.
Heard Mr. Mukherjee, learned counsel for the applicant, and Mr.
BB Kaput.
BB
Kaput.
learned counsel for the respondent number 1. Mr. Mukherjee submits that his interlocutory application is preferred for correction of the father's name of the respondent number 2. And the same has been reflected in the cost title as son of late Dandeswar Borua, who is thought to have been son of
late Radha Mohan Sahani.
Late Radha Mohan or Mangal?
Mohan.
Radha Mohan Sahani. And as such, this interlocutory application may be allowed for correction of the name of the father of the respondent number 2. But having heard the submission of learned counsel for both the parties, the interlocutory application is thence allowed. The name of respondent number 2, father of the respondent number 2, be corrected as son of late Radha Mohan Sahani. In terms of above, this IA is thence disposed of. The applicant shall take necessary steps for filing amended cost title within a period of 1 week from today. 1 week.
1 week.
For 3 working days from today.
34. Here, Lordship, IA civil number 2037, Lordship.
for condonation of delay, Lordship, in filing a substitution application, Lordship. During the pendency of this case, Lordship, respondent number 7 has died, Lordship. That we have filed a substitution application, and there is a delay, Lordship, in filing the
So you are appearing for?
Appearing for respondent number 8. On the
For substitution of legal heirs of respondent number
7, Lordship.
7.
7.
Where you have mentioned it in your application?
A delay condonation application, Lordship.
You come to page number 2 of your application.
For 2034, Lordship. I had 2034.
2037.
37, Lord. It's a delay condonation application, Lordship.
Yes, all right. For substitution of legal heirs of this is respondent number
Lordship. I have not mentioned, Lord.
Take necessary correction only, then we will
Lordship,
consider your
Lordship.
pair. On the pair being made by Mr. Kokon, learned counsel for the applicant, raises shall list the matter immediately after reopening of the petition.
Oblige.
35.
Matter will be taken after some time. I think Mr. Ken Chaudhary is on next in the court. He's coming on. He's coming.
What is the matter?
Matter, my lord, the primary membership of the petitioner, my lord. He has primary membership of the petitioner from the Sankar Sangha, my lord. That has been, my lord, terminated. Initially, it was suspended. Secondly, it was terminated. That, my lord, against that, my lord, we approached the honorable civil court, my lord. Civil court, my lord, though notice was issued on the interim prayer also, no injunction was granted. Against that order, my lord, we have preferred this CRT, my lord. Without issuing any notice, my lord, my membership has been terminated.
Mr. Mazumdar, can you tell me whether it is civil revision petition will lie or appeal will lie?
Well, they have filed an appeal. In the appeal also, they filed, what has happened. Before the trial court, they filed this and paid for temporary. Injunction was not granted, even ad interim, not ex parte, injunction was not granted. Only notice was issued. Instead of filing any objection there, they have preferred an appeal against that order of issuing notice only. Before the appellate court below. Additionally, before the appeal, they ordered change the order and filed a separate application, again praying for an injunction, ad interim ex parte. That was also refused. Against that refusal, appeal is pending before the first appellate. Against that refusal by the appellate court, they have filed this pseudo request.
Acha. Acha.
Petition may be maintainable, but the fact remains, my lord, law is very clear. Before the trial court, normally notice should be issued. Notice was not issued. Notice was issued, and in case where the court finds that in an exceptional case, ex parte without notice, injunction is to be granted ad interim is granted. But for that, a strong primary case is to be accepted. And in this case, my lord, their membership was suspended only.
No,
and subsequent termination is not under challenge in this case. Subsequent termination of his membership is not under challenge in this case. Not this matter. In this case, it was temporarily suspended. And if they are praying for an injunction, that order should be suspended so that they can participate in the meeting. This will amount to giving the final relief in the suit. Whatever prayer they prayed in the final relief in this plain manner, there they are praying by way of an injunction. If that temporary injunction is granted, it will amount to giving the degree itself. And the trial court has recorded a finding that considering the facts and circumstances of the case, notice is required to be issued, other side is required to be heard. Against that, they preferred an appeal. Appeal is pending before the appeal court. Again, they have prayed for a temporary ad interim ex parte injunction that was again refused. Against that, they have come there again here, they have filed an appeal and again praying for a temporary injunction. This is heard by the trial court.
In the meantime, the person was terminated from the membership.
That I am not. I mean, that is not the subject matter of this. It's not subject matter of this.
That is also a fidget matter. That is also
No, there is no. Let us it is prayer in the plea. Well, page 79 is the prayer. Page 79. Prayer made in the plea.
In the main petition,
My
both the orders are on the challenge. Both the orders are on the challenge, but that suspension order, that is 1/7/2024, and the termination order 27/2024.
No. 27/24 is not termination. It is a press release.
No. 27 is the termination order.
Page 43. Page 43. Well, what may kindly have a look at page 40. This is the first letter they are taking. Page 40 is the letter dated 1/7/2024. My lord, Lordship kindly see the next page, the brief, next page 41. The brief discussion was held, it's a translated copy, my lord. Brief discussion was held on report until the final decision is announced by the next executive meeting. Sri Babu Bora, who is the petitioner before Lordship, and Sri Swelto is suspended from all responsibility of Himanta Concordia Congo. This is the first one.
That's page 44.
And then page 43 next is the translated copy. Page 43 is a translated copy of this press release of this letter.
My lord, in the translation, my lord, there is some mistake. Lord, should we kindly take up the original one, my lord, at page 44.
yes,
44. May I read that? শ্ৰীমন্ত শংকৰ সংঘৰ এটা আভ্যন্তৰীণ বিষয় সন্দৰ্ভত অনুসন্ধান আৰু বিচাৰ প্ৰক্ৰিয়া চলি থকা সময়ত মূল কাৰ্যনিৰ্বাহক সভাই ইতিমধ্যে নিষ্ক্ৰিয় কৰি ৰখা বিষয়টোৰ অন্যতম অভিযুক্ত শ্ৰীমন্ত শংকৰদেৱ সংঘৰ প্ৰাক্তন প্ৰধান সম্পাদক শ্ৰীযুত বাবুল বৰা বাপে যোৱা 5/7/2024 তাৰিখে নিজ বাসগৃহত সংবাদমেল অনুষ্ঠিত কৰি শ্ৰীমন্ত শংকৰদেৱ সংঘৰ অধিৱেশনৰ 27 সংবিধানৰ 27 ক দফাৰ 1 খ উপদফা আৰু 27 ক দফাৰে 3 ঘ উপদফাৰ সাংবিধানিক নীতি আদৰ্শ ভংগ কৰাৰ লগতে সংবাদমেলত অশিষ্ট আচৰণেৰে শ্ৰীমন্ত শংকৰ সংঘৰ বিষয়ববীয়া আৰু অনুসন্ধান কমিটিৰ সদস্যৰ প্ৰতি আশালীন মন্তব্য কৰাৰ বাবে শ্ৰীমন্ত শংকৰদেৱ সংঘৰ 18/7/2024 তাৰিখৰ জৰুৰী কাৰ্যনিৰ্বাহক সভাত বিস্তৃত আলোচনাৰ অন্তত সৰ্বসন্মত ক্ৰমে সংবিধানৰ 28 দফাৰ 1, 2 আৰু 3 উপদফা অনুসৰি অনুশাসন ভংগ কৰাৰ অপৰাধত শ্ৰীমন্ত শংকৰদেৱ সংঘৰ প্ৰধান সম্পাদক শ্ৰীযুত বাবুল বৰা বাপৰ সংগীপদ তাৎক্ষণিকভাৱে কাৰ্যকৰী হোৱাকৈ বাতিল কৰা হয়। This is the termination. This is also under challenge.
No, let me on top of the press vignapti. It is a press release.
It was not served upon me, my lord. They have given the press vignapti instead of serving me, my lord. I was not given even the so-called, no notice was issued, nothing was given. Only, my lord, they have given the press vignapti instead of, my lord, serving it to me.
okay, let Mr. Chaudhary come.
My lord.
Or my lord, we file their objection to their revision petition, what may take it up after 6 minutes.
My lord, they have entered appearance in the month of November. Till that, they have not filed any objection, my lord. Let the IA be taken up today, my lord. Let them file, my lord, objection against the revision petition. I have no objection, my lord. Let the IA be taken up today, my lord, in presence of my senior.
36.
Can I take for timing of this matter? It's possible.
Timing.
Two minutes.
We have only two matters.
41.
May I please, your lordship? Just as far as matter, lordship wanted to produce the subsequent order sheet. My learned. I've collected from the court below, lordship. Parties are in. First page the type copy, what next page lordship found court's order, lordship and written.
Which is the relevant order?
Relevant order lordships 2011-2024. First page bottom fine lordship. Both sides are represented today with fixed argument. Our defendant side submitted copy of the order dated 18/2024 passed by the Honorable Guwahati High Court in CRPI number the fixed on 18/12/2024 for necessary order from JH.
What is your pair in this IA?
Prior in the IL lordships, CRP notice was issued. LCR scan copy of the LCR has been called from the court below. Judgment was not staged. My prayer is that till pendency of the civil division petition, the proceeding of the court below entitled to 25 of 2013, that may be stayed lordship. Prayer in the IL lordship.
Pardon, sir. Yeah. Or we are learned for the applicant. This interlocutory application is deferred under section 151 of the Code of Civil Procedure for staying the proceeding of PS number 25 of 2013 pending before the Court of Law and Civil Judgment Division number 4 after Sir Barbuya learned for the applicant that against the order dated 6/8/2024 passed by the learned civil judge. Which is the impugned order, 6/8 or 13/5?
Both lordships, 13/5
Against the
2024
order
and
dated
6/8 both.
13/5/2024 and 6/8/2024 passed by the learned trial court. He has preferred one similar revision petition. Being CRP number, CRP IO number 462 of 2024. And in the said proceeding, this court was placed to call for the scanned copy of the record.
On 18/11/2024.
By order dated?
By order dated 18/11/2024.
18/11/2024. 2024. And that there is a requirement of staying the titles of number 25 of 2013 till disposal of the number 462 of 2024. Otherwise, the petition would be infructuous. Having considered the submission of learned counsel for the applicant and also considering the given facts and circumstances of the record, this court is inclined to stay further proceeding of PS number 25 of 2013 till returnable date in CRP IO number 462 of 2024. Let the other side appear, therefore we consider. In terms of this IA stands. No, not that. List the matter after after
in CRP 4 weeks.
List the matter along with IO number CRP IO 462 of 2024.
Madam, 42.
Obliged.
Very please, lordship.
Here in this case, Lordship, I am praying for release of the amount deposited by the insurance company, Lordship.
Mr. Bhatto, any objection? No. Heard Mr. Talukdar, learned counsel for the applicant, and Mr. Bhatto, learned counsel for the respondent. Mr. Talukdar, learned counsel for the applicant, submits that pursuant to an order passed by this court in MSC Appeal number 463 of 2024, the appellant, respondent hearing, has deposited 50% of the awarded amount before the registry of this court, and that the
Lordship,
applicant may be permitted to withdraw the aforesaid amount from the registry of this court.
Lordship, 20% of the awarded.
20%,
Lordship.
not 50%.
20% of the awarded.
20%.
And the amount is mentioned, Lordship, 8,56,480.
Where?
In the post title. First page. Lordship.
But you have not enclosed the order.
Lordship, one close. Annexure A, Lordship.
Annexure?
A.
Where 20% of the awarded. Sir, Bhatto, learned counsel for the respondent, appellant, Mr. Respondent hearing, submits that he has no objection. Accordingly, this court is inclined to allow this. Inclined to allow the applicant to withdraw the 20% of the amount, awarded amount deposited before the registry of this court.
Lordship, amount may be mentioned. Amount is there, 8,56,480. First page.
Page number?
1, Lordship. Post title.
Of the IA. The
IA,
IA.
Lordship, IA.
Page number 1.
1.
Is it there?
Lordship. IA civil number 396024.
It is only 8,000, 8 lakhs or 50,000, 56,418.
Lordship.
Is it? Awarded amount, 20% of the awarded amount. That is rupees 8,56,418 rupees. In terms of this IA stands closed.
Obliged.
Yes.
Lordship has seen the suspension order and the termination order, madam. And
So by
the
that
mention.
I'm just pointing out, termination was there on 18th. Press release of 20th. They have changed the press release of 20th. 18th they have a challenge. In the present revision petition, they have changed that as a termination. Plain they have not amended.
Whether that has been communicated to me, madam.
No, communication is another thing.
It was never communicated to me, madam. Whatever I received, I got the press release. That only I had to challenge. They have made the
No,
decision.
press release you cannot challenge.
No, I'm
I
not
don't
challenging
think
the
so.
press release, madam. I'm not challenging the press release, madam. I'm challenging the decision published in the press release, madam. Obviously, the press release, because that decision was not communicated to me. Decision was not communicated to me. That's why I have challenged the decision through the press release, which I came to know through the press release.
No, where you have enclosed the that decision?
Decision I have, it has never been communicated to me, I have stated that, I have made a statement in the plain as well as in the CRP also. It was never communicated to me. They have terminated me without issuing a so cause. My primary membership has been terminated. Whether that is permissible? If I have done anything wrong,
That's all right. If you have been
if I have done
terminated,
anything wrong,
you are to
possibly kindly
produce
peruse the
the
provisions which they have alleged to be violated. Possibly kindly peruse those provisions of the Constitution. Possibly kindly peruse.
If it is not communicated, how they have challenged in the present revision petition? In present revision, just look. Page 19, madam. Page 19, they have specifically changed it to terminated. Page 19, from 1 to. By setting aside the opportunity letter dated 20 July 2023, whereby the membership of the petitioner was terminated. This termination is not under challenging the suit in the plain. In the plain, only the press release. Now they have realized possible termination is to be challenged. Now they are challenging it. That's what I'm pointing out.
Kindly see the termination order, the press release through which I came to know about the termination.
you produced the order, termination order.
Termination order, I was never communicated. So, it is the Sankar Sangho, who will produce the order, Termination order has not been communicated till today. Till today, it has not been communicated.
The manner in which my submission is, manner in which they have made a prayer in the revision petition, this prayer could have been there in the play. See, you have terminated, I am against your, I am challenging the termination. This is what I am saying. They are challenging only the press release. Press release is an intimation. And in the plain, nowhere they have said that they are agreed by the termination. Somehow there are somewhere gaps. In the plain, there is no allegation that my termination is bad. They are challenging only the suspension of 1/7. On 1st of July, there was suspension of his membership. Subsequently, it was terminated on 18/7.
Yes, in the plain also, same is under challenge. Page 21, Roman 3.
My lord, subject to what my learned friend says, my lord, what I was thinking, my lord, let the date be fixed. Let us appear before the trial court, and on that date, the trial court will, my lord, decide the injunction matter.
Fair enough. Fair enough. I agree.
But on that date, we'll appear, and he will hear, the learned trial court
And
will
in
hear
the
it.
meantime, we'll file our.
Of course, of course, of course.
Yeah. May your lordship make it so.
Okay.
That is.
Heard Mr. Ken Chaudhary, Learned Senior Counsel, assisted by Mr. I.A. Soikia, Learned Counsel for the petitioner, and Mr. T. Mazumdar, Learned Senior Counsel, assisted by Mr. Datta. P.B. Datta, Learned Counsel for the respondent. Mr. Ken Chaudhary, Learned Senior Counsel for the petitioner, submits that the matter may be remanded to the Learned Trial Court with a direction to dispose of the petition after hearing both the parties and affording
7th of January, my lord.
affording opportunity to the respondent hearing to file objection.
7, my lord.
Immediately after the meeting, he must go.
No, he'll come. High Court reopens on 3rd. That's why I said 7.
Okay. Having no, Mr. T. Mazumdar, Learned Counsel for the respondent also considered to the submission so advanced by Mr. Chaudhary, Learned Counsel for the petitioner. Having heard the submission of Learned Counsel for the counsel for both the parties and also considering the facts and circumstances of the record, this court is inclined to remand the matter to the Learned Trial Court to dispose of the petition within a period of
On 7th will
On
appear on
7th.
that day,
On
trial court will decide, my lord.
on 7. So he has to file objection
But
there.
today is there a lot of time, my lord. Today is, my lord, 18th only.
Yes.
More than 2 weeks are there.
Okay. On 7th, 7th of January, in the meantime,
Filing within 3/3, let the hearing, let the hearing take place just immediately after the petition, just after an unpaid motion.
immediately after reopening. of
Yes.
the court.
But before that, we'll file our.
And before the next date, the respondents will file their objection before the learned trial court. In terms of the CRP and the IA stands.
Lordship will fix a date, my lord. I was suggesting 7, they say after Bihu. All right, let it be on 21st. 20
20
is a Monday. তাতো আৰু কিবা আৰু বহাগ বিহুৰ পিছত লাগিব নেকি?
Okay.
Timing item 36. 36.
এটা আজি কোনটো আহিছে? My lord, what had happened in this case, we have filed an IA on behalf of the Tezpur Law College principal, my lord. Now, it's a case of a student, but nevertheless, my lord, merely because one is a student, they cannot take law onto their own hands. What had happened, my lord, the freshers social for the year 23-24 was fixed on a particular date. Now they submitted some inflated bills, the students' union. So principal did not agree. Then what happened, my lord? From the college side, the function was organized. On the date fixed when the function was going on, the writ petitioner and another person, led by some other hooligans, my lord, they overtook the stage. Everybody was, my lord, removed from the stage and created a chaos. Now, thereafter, my lord, by serving a show cause notice, an impugn order was passed, whereby certain measures were taken. Amongst others, my lord, he was prevented from appearing in one semester. Now, against that, a writ petition has been filed. Now, my first point is, my lord, Tezpur Law College is not an other authority within the meaning of Article 12. Therefore, this writ petition is not maintainable. Number 1. Number 2, my lord, in an appropriate case, if even in respect of a private body, some statutory duty is cast, then, my lord, to enforce that statutory duty, even a writ would lie against an authority which may not be an authority under Article 12. But here, what he is trying to do is, my lord, he is trying to enforce his personal grievance. So for which a writ is not maintainable, my lord. It's a private college. Had it been, suppose
perhaps that law college was taken over by the government.
No, my lord. No. Private college. Even our Guwahati, other than BRM college, all are private colleges. No, Tezpur Law College is not a government college.
Sometimes back, Chief Minister made one statement that.
Or maybe it is in the process, but it has not been done.
Not been done.
Not been done. So, my lord, to, enforce a personal grievance, how a writ would lie against a private body? The very language of the Article 226 is very clear. And, my lord, end of the day, these are all money. Now, you submitted an inflated bill, college did not accept it. Then you overpowered everybody. So, therefore, my humble submission is, my lord, this writ petition is not maintainable. If he has got any grievance, he should go to the civil court and fight it out. This writ petition is not maintainable. I have clearly made that averment, my lord. These are all supported by case laws.
So this IA is
For vacating
maintainability.
vacating the interim order, my lord. If your lordship would kindly come to paragraph 12, my lord.
Of the writ petition.
Of the IA, my lord. A writ petition is there. Page 13, para 12.
Yes.
That the applicant begs to state and submit that Tezpur Law College is not an other authority with the meaning of Article 12 of the Constitution of India, as it has not been created by any statute and its existence is not dependent upon any statutory provision. The college is affiliated to Guwahati University for the sake of convenience, namely for the purpose of recognition and syllabus or the courses. Therefore, in the humble submission of the applicant, it does not confer any enforceable right upon the opposite party number 1 against the college. It is pertinent to state herein that writ jurisdiction of this honorable court can be invoked for enforcing a public law element and not to enforce a personal grievance. Applicant begs to state there is no doubt of that the aims and objectives of the college are to impart legal education, which is a public function. However, the issue herein is with regard to imposing penalty upon opposite party, which is purely within the domain of the discretion of the college to maintain discipline in the college. In the present case, there is no question of public law element being involved, inasmuch as grievance of the opposite party is of personal nature and therefore no writ would lie against a disciplinary action imposed upon opposite party number 1 by college, which is a private. On maintainability of the writ petition, this is my case. But you would recollect that case of 1989, when, my lord, whether this question arose, whether a mandamus can be issued against a private body. Now, if I am to enforce, supposing, my lord, supposing I am working in an establishment. I am giving an example. My lord. In that establishment, I am working as some workman. Now, supposing payment of my wage, etc., is governed by some statute. Now, if the payment is not made in accordance with that statute, then I can maintain. Because there I will be seeking to enforce a public duty. Here, my lord, he is guilty of indiscipline. So, my lord, college has taken certain measures against him. Now, that is a personal grievance. That writ court cannot enforce. You cannot.
What remedy is available?
Suit, my lord. He'll have to file a suit.
Civil court.
Civil court. Well, there are up to number of judgments on this point. So, prima facie, my lord, my humble submission is this writ petition is not maintainable in its present form, and having regard to the nature of the, my lord, prayer which they have made.
Yes, what is your submission?
Pursuant to the contentions put forward on my respective opposite side. My lord, I would like to rely on one judgment, my lord. Party state for the CBCI society which I have just mentioned. My lord, I have marked the relevant paragraph, my lord. Paragraph 28 of the state. Paragraph 28. My lord, I will be dealing with the maintainability part, because this was also a private college, my lord, whereby it said, I'll just read the effective part. 28, my lord, the one I have highlighted.
Yes.
Whether no writ petition is maintainable against an affiliated college for enforcement of a statutory provision. It should be pointed out in the first instance that a private college is not just like any private individual or establishment doing any business or carrying any avocation. Education is an obligatory function of the state. Therefore, the state, in discharge of its constitutional obligation under Article 41, 48, read with entry 25 of List 3 of Schedule 7 of the Constitution, provides for the establishment of the educational institutions by the government directly or through any university established under an act of legislation. It can also
you say here in the third line it is stated that for enforcement of a statutory provision.
Yes.
My lord, the Tezpur Law College is amenable under the writ jurisdiction because it is the creation. My lord, it is affiliated to the Guwahati University. That is a creation of a statute. So it is amenable. My lord, moreover, my lord, in their IA, my lord, they have stated that it is registered. It is a registered society. It is a part of the IA. Now, my lord, I would like to put forward one more apex court judgment, my lord. Virendra Kumar Srivastava versus P. Rajya Karmachari, my lord. I flagged the important. My lord, here also it is a society, my lord. My lord would kindly find the flag portion, my lord. And the end portion, my lord. The end page. That is page 161. Last page. Here, my lord, there was one judgment, my lord, which has been discussed here. Pradeep Kumar Biswas. My lord, Pradeep Kumar Biswas had overruled one judgment that was, my lord, passed by the Honorable Apex Court in my lord, Sabajit Tiwari. In Sabajit Tiwari, it was said that Article 12, my lord, Article 12, my lord, these institutions, it will not be considered as a part of the state. But that was overruled, my lord, in the judgment, my lord, Pradeep Kumar Biswas. Thereafter, my lord, taking the contentions of Pradeep Kumar Biswas, my lord, Virendra Kumar Srivastava was upheld, my lord. Para 27, my lord, the last page, my lord, I'll just be reading the relevant portion. On detailed examination of the administrative, financial, and functional control of the corporation, we have no manner of doubt that it is nothing but an instrumentality and agency of the state. And the control of the state is not regulatory, but it is deep and pervasive in the sense that it is formed with the object of catering to the needs of the government employees as a supplement to the salaries and perks. Here it was about government employees. My lord, my bone of contention is that since, my lord, it is an instrumentality of the state. My lord, in Sohan, my lord, I have one more judgment. My lord, in Rajasthan, SEB versus Mohanlal, AIR 1967, 1857, my lord. Even here, my lord, it was observed that the state is defined in Article 12, thus comprehended to include bodies created for promotion, purpose of promoting the educational and economic interest of the people. My lord, my bone of contention is that, my lord, this college, although created under a society, my lord, registered under a society, registered as a society, but my lord, it is amenable to the writ code. It falls within the definition of Article 12 because, my lord, it is performing quasi-public functions, my lord, quasi-judicial functions, quasi-public functions, as observed in RK6. And, my lord, my humble submission, my lord, there was a rift, as my respected senior had just put forward before this honorable court. There was a rift between I was a part of the student body. I was the vice president of the student body. Now there was some rift, my lord. There is one important fact, my lord. For organizing the event, the freshman social in question, we had to borrow some money from a fellow student. Now, while doing so, my lord, the student from whom we had borrowed, his father passed away in the meantime. The amount of rupees 30,000 we had borrowed from him. And, my lord, when his father died, his elder brother had actually told us that we pay the said amount, otherwise we'll do a FIR again. That is why, my lord, we were also under this pressure, my lord, lurking fear of being arrested. Now, my lord, we had no other option. In the most peaceful and democratic manner, while exercising our rights under Article 19, my lord, freedom of speech and expression, we had approached the stage when the program did not come. When the stage was empty, we just went there. We told there were just 10, 15 students, and we told them, this is the pending amount.
Now we are not on facts. We are on the law point of whether petition is maintainable or not. That is the question.
It is amenable under the writ code. Because it performs public functions, my lord. And, my lord, the three elements that was considered, my lord, in Pradeep Kumar Biswas, my lord, that is administrative, financial, and one financial control, functional control, and administrative control. Now, my lord, it is directly affiliated, it is there in the website also. It is affiliated under the Guwahati University. Therefore, that is why, my lord, this administrative control will be satisfied, my lord. Guwahati University thereafter, it is the creation of a statute. So that way, my lord, if we go by that, it is very much under. Otherwise, my lord, if we have to approach the civil court, the exams are going to start from the 31st of December. If we don't get a stay for some reason, my lord, because we do not know the outcome of the civil court, we might get an interim, we might not get. Then, my lord, what? I lose the semester. My lord, there were five allegations, 5 disciplinary actions against, barring me from appearing in exam, attending classes, then appearing in public functions, taking part in elections, and one more. My lord, this honorable court had used its judicial power and had suspended 3 actions, my lord. That is, one, my lord, allowing me to appear in the exam, allowing me to take part in the sessional exams and everything, and, my lord, appearing in classes. My lord, this honorable court was pleased to allow me this so that I don't lose a year. Otherwise, it will affect my academics, my lord. I'm a final year student of 3-year LLB. Now, my lord, if I am not allowed to appear in the said examination, I'll lose a precious year. And my lord, I have already apologized. My lord, would kindly have the writ petition for a moment, my lord. My lord, would kindly have page 56 for a moment, my lord. If I may read with the permission of the to principal IC, page 56, main writ petition. Writ petition number 5662 of 20. May I read my 5?
No, not necessary.
This is my apology, my lord. And that 30,000 rupees which I just argued about, that much. And we are again ready to apologize because my lord, yes, my lord, we shouldn't have approached it. Although we have approached the stage in a democratic manner, my lord, by expressing our views because we are under the pressure, my lord. But still, my lord, being students, my lord, they are our teachers, my lord. We are always ready to apologize. But my lord, not allowing us to appear in the examination is going to catastrophe for our.
Yeah.
Mr. Chaudhary,
My lord.
Can some leniency be shown to him?
No, my lord, leniency has been shown by this
Not in this petition. It is at your level.
Let it come up for tomorrow, my lord. I'll have a talk.
Tomorrow?
Tomorrow. At 2 o'clock, Lordship will take up the matter. I'll take instruction.
Tomorrow, I may not be available. Day after tomorrow?
Day after tomorrow.
Day after.
My lord, my learned friend has argued the case well, but I was trying to tell him, my lord, when we refer a judgment, we must read the facts. Because it is said, a judgment is an authority for what it actually decides. Because a judgment should not be read as like a statute. Because see, the first judgment my learned friend realized, it supports me. Because as I have already said, the Bandi Mukta, that 89-2S is the first case on the point. If, supposing my lord, this LN, Bansal classes, they dismiss one of their employees, they'll come to read court because they're imparting education. That's not the issue. My lord, the tester, to become an authority under Article 12, there must be deep and pervasive control of the state. There must be finance of the state. Where is this? Does government of Assam pay anything? No. Does government of Assam appoints the principal or vice principal? No. This doesn't, it's not a authority under Article 12. My lord, actually what had happened, if we read the judgment in Dayaram's Ramanna Dayaram Setti's case, where Justice Bhagavati for the first time propounded this principle, my lord, with the advancement of our society, with the increase in the activities, the governmental functions also increase manifold. Now these typical bureaucrats, my lord, that civil servant, IS, they were not in a position to cope up. That is when, my lord, this enterprise system came up. Either it was created by a statute. For example, my lord, earlier it was Assam State Electricity Board, then Assam Financial Corporation, or it will be registered as a cooperative society, where directors will be appointed by the government, finance will be provided by, those are Article 12. But in an institute, maybe it is in society under Societies Registration Act. But if there is no deep and pervasive control of the state, then it ceases to be an authority under Article 12. So by any reckoning, Tezpur Law College cannot become another authority. But on the point, my lordship has said, I'll take up the matter, let it come up day after tomorrow.
No, at least he may be allowed to appear in the.
Yes, no, see, I think by virtue of the judgment of the interim order, he has already appeared. No, anyway, my lord, let it come day after tomorrow. I'll have the instruction.
As agreed by learned advocate about both the parties raised the matter day after tomorrow at 2 p.m. as part-heard method.
Deeply obliged.
My lord, the interim order.
Okay, interim till day after tomorrow shall continue.